Here I am again. Trying again. Oh, there we go. Oh, no, that's not it. Oh, it just doesn't want to show me. Okay. That's scary. That's so scary. Maybe it's this bad screen. What? Oh, there I am. There I am. Here I am. Here I am, kids. All right. Let's try that and see if anybody wants to come in and talk about the failed 2020 erection challenges. I'm going to do David Bowie. Talk about the 2020 election challenges. And we are going to the show. Come on, get ready to go. I think I'm viewing my own stream, by the way. Yeah, I am. Oh my God. You're such a loser. Oh, what? What's that? Wait, what's that? What was that video? Oh, I see. That one was dumb. Okay. Am I live? Oh, yay, Pepper. Phew. God, I thought it was Twilight Zone. I thought, this is it. This is it. This is it. No. Hi, Kathy. I'm going to start it back. We've only missed like 20 minutes of it, so I'm going to start it shortly. In fact, I'll put it up. Let's pull her up now. Oh, no, 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 no. Election frauds are frauds. Yeah, we don't like frauds. Nah. 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 Okay. All right. So if you remember when we last left you on Adventures with Maggots, when we last left you, Stephen Richer was done, and they were going to go on to their, I don't know what they were going to do. If there was a cross-examination, I'm not really sure. Hi, Jen. How are you, darling? Do you have the day off? I hope you don't have to work today. But now I probably said it, and you probably do, and now you're reminded that you have to do, and now you're probably pretty mad at me. Don't you love it? She's doing sexy prisoner. Yeah. I just need to get rid of her shoulders. She has extra shoulder pads. Yay! Oh, I'm so happy. Hurrah. 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 Okay, well, let's go watch this motherfucking hearing. Piece of shit.
I'm ready to go. All right, we're back on the record. Before we start, let's see, we had some documents to deal with, Mr. Byrne. Are you ready, or are you still working on those?
I'm sorry, sir. I sent off the.
Oh, thanks, Jen. It's good to see you. Your smiling, beautiful face.
You had 4 documents.
I think
I cut it down to 3.
Just
to 3. All right, have they been provided to other council?
Yes, I sent them off before for lunch.
You don't want to come on my show and just try it out?
All right, if ODC needs a little more time to look at them, we can wait.
Yeah, we do. And I'd also request that some of the documents have either been highlighted or redacted. I don't know if that was Mr. Byrne who was doing the highlighting or redacting, but we'd like this documents in their original form.
Well, I'd be happy. I'm sorry, I wanted to get them out. Nothing has been redacted, and we can certainly take
some of
care
them
of that.
had like
just to give you a little more orientation.
Pages of the article, and then there's like
this
comments
guy
and advertisements.
Right.
There was
this guy's just part of the panel who decides.
I got it.
This guy's the head of the panel who decides. This guy's a public
I'll just make
member
the
of the panel
representation
who
that the
decides.
articles and the.
This is the Office of Disciplinary
Further,
Counsel. So
can we
these are
turn
the
off, is
lawyers
it
for the
possible to turn
bar.
off the computer audio?
This is where people stand. That guy's
Not
there. And then
hearing
this
them
guy,
that
Brandon
well.
Johnson, and his lawyer, he's
All
on
right, Mr.
trial.
Burns,
Who's
so
not here is Julia Haller.
are the documents you provided, do they have any
Love our
redactions or
lawyers.
not?
Oh,
No,
there's
the
Julia
only
right there.
redactions
Sorry,
are
Julia's in the middle.
at the end of, when you
But I don't
download
know where her
something,
lawyer
sometimes
is.
there's a few pages of
'Cause
advertisements
there's a couple people
that are
missing.
unconnected to the article. And I think that the articles have the end point of the article, which is clear. So certainly it's my understanding that there are no substantive redactions, and the only redactions are
So say
that
you.
were advertisements.
Dude,
Since there's only
you're the
3
fucking respondent's
documents,
lawyer.
I'll be happy to recheck. And we'll also take the highlighting out.
I'm not taking your word for
And
shit.
they'll have them
Just
for,
saying.
in final form, but certainly they're able to be examined at this point and assessed.
All right, so you're gonna provide unhighlighted copies at some point?
I'll do that either now or at the break. I can do it during Mr. Joseph's testimony. Yeah, absolutely.
Well, why don't you get them to ODC and other counsel as soon as possible, and hopefully we can get them resolved today
Yes, sir.
instead of bringing them back. Let's see, were there, Mr. Driscoll, did you have some documents you wanted to move into evidence?
Yes, sir. The upload document that we were referring to with Mr. Richard, that's actually JHX 146. That's already part of our exhibits. The 3 documents we wanted to move in addition to that, were the 2 forensic audits, the Pro B&V and the LSI compliance, and then the certification of the Dominion Democracy Suite 5.5A by the Secretary Hobbs for Arizona.
All right, have those been marked? Do we have them?
I will get them marked before the end of the day and circulated to everyone, but I believe I now know what the numbers will be. I can bait stamp them and submit them to everyone.
Okay, why don't we do that?
Okay.
Were there any other documents we need to deal with right now? Mr. Joseph?
I did look into the emails, or sorry, the Excel information over the break. And I do not have the original sort of clean Excel spreadsheets, but I had one that I had appended to. And so I provided those. I didn't know whether to put a document number on them or not, but I provided those to the
You have those in electronic form or?
I emailed, I had 2 quote filings. The first one was, here's the Pennsylvania spreadsheet. And the second one here was, here's the Georgia spreadsheet.
That's one of the defendants or respondents.
Yes,
Sorry.
I think that's a yes to
Not
your
criminal.
question.
All right, do you want to move something into evidence?
No, I was just providing those at the request of the hearing
What?
committee. I thought.
Jen?
Sorry.
What?
You want those?
What?
Yeah, we like to have those before us. Have they been provided to other counsel or Megan or?
Yes, case manager copied all counsel, yes.
And to Megan?
Oh,
Yes. Yes, they were provided to me and I forwarded them to all of you.
All right, do they have numbers?
I didn't know if I was supposed to number them because they're not.
All right.
Exhibits. They can be if you want.
Yes, I think that would, we need to know what, we're going to refer to them in later, certainly be, it's necessary that they have exhibit numbers. So it'd be your exhibit number or whatever.
They already are an attachment in flat paper format or PDF format. They already have an exhibit number in that regard. They're just the electronic backup so that it's more useful. In other words, you have to flip through the weirdly paginated Excel printout, which well, I think you have it from them, and you maybe will also have it from me with the different LJX exhibit number. But all the Excel spreadsheet it gives you over what was printed. It's the same literal characters, but it's just more useful in this electronic form. But I'd be happy to figure out how to stick a number onto just the spreadsheet, and that would be a spreadsheet exhibit that you find.
All right.
I mean,
Why
it
don't you
takes
do
a lot
that?
to break.
All right, so I'll
if you're
resend
gonna
that
break
this
into a
evening.
post office, that's
All
a
right, I
serious
think we're ready for
thing.
you to
That's not just
resume
like,
the witness
"Oh, I
stand
wanna-"
then.
Mr. Chairman, just,
That's pretty specific.
I sent off those exhibits, so everybody should have them.
I don't know.
All right,
The copies that we received earlier didn't have any exhibit number on them, so.
But we're not sure that they're even gonna be, admitted, so
Wow.
I thought that we were gonna discuss them, so.
you need to put an exhibit number on them so we can then move them into evidence. Otherwise, we're guessing
Okay,
later on what documents were offered and what their status is.
Mm.
okay.
Yes.
Oh, good, easily. Excellent. So glad. You better rest. Banana. You better rest. Okay.
Still under
You
oath.
know what? I'm going to
Yes,
try
you're
and
still
put these
under
guys
oath.
on speed here a little bit.
Good afternoon, Mr. Joseph. And before we broke to conclude Mr. Richard's
We're going
testimony,
to,
I was asking you
1.25
about the
speed.
Texas versus Pennsylvania case, and you were counsel for the state of Texas in that case, correct?
Correct.
And you indicated that this was
come
an
back to
elector's case and that you were challenging, I guess, signature verification and other election administrative procedures in the 4 states that you sued.
I said all those things, but to put them together in the way that I did, I use the signature verification as an example, and it's the electors and elections clauses, and I believe that it says the host has asked you to start your video. Is that something I need to do?
No.
David needs to start it, I think. Thank you.
Okay, sorry about that. And then the complaint, because it's essentially an original case. It has a leave to file a complaint, I guess is what you're asking for. It had allegations of fraud in it, and it had electors and elections clause in it, and different people worked on different things. And what I worked on was the elections and electors clause. So with that clarification, what you said was all correct. I just wouldn't put it together that way.
Okay. And so, as you just testified, that complaint or leave to file that complaint also included allegations of fraud.
That's correct, I think.
And you were aware of those allegations when you agreed to be counsel and sign off on the submission to the Supreme Court.
Again, it's something similar. I was listed as being one of the counsel, but I didn't sign the document. But yes, with that caveat.
And you knew, I guess, just putting a time frame on it, the Texas versus Pennsylvania lawsuit was filed on December 8th, 2020.
Watching linked above.
I thought it was the 7th, but maybe.
The 7th or the 8th. Prior to that, you knew that there were challenges of, I guess, the election administration issues that you raised, correct?
We're going to be getting into a fight about this someday, I'm sure, but I'm pretty sure that. So let me back up. There's Article 3 of the Constitution, which talks about what federal courts can and can't do. And the electors and elections clause issues have largely been held to not be within an Article 3 injury to the plaintiffs that brought them. So in Ducey, your Arizona case, in King, the Michigan case, in the Georgia case, they said that there was no standing to reach those, and so that means they didn't reach them. In other words, let's say King versus Whitmer, they lost on the merits. They were held not to have. Well, I'm not even sure they might have just dismissed that case. The case, I guess, where they actually dismissed it.
How about Trump versus the Wisconsin Election Commission? That was actually, it was heard. There was evidence. There was at least stipulation as to evidence, and Trump lost that case.
Okay, I'm less familiar with that, but that sounds like maybe one where the 7th Circuit, I think, said that there was standing for the elections and electors clause. I'm not familiar with that because I didn't look at it for these 4 cases. But my point is that
do they get something out of it?
I guess I don't know which cases were dismissed by the court as opposed to eventually given up and dismissed by the plaintiffs. But when a court does not, when a court dismisses a case, you haven't proved fraud, you lose on the merits. And I'm not going to listen to your electors clause case because you don't have standing for that. That means they didn't lose that part of it on the merits. And so when you're saying that, well, the Texas versus Pennsylvania was bringing these cases that had already lost.
How angry this makes me.
First of all, losing in district court doesn't mean you've lost on the merits. A district court decision is not binding precedent against someone else. And I have a citation for that if you're interested.
I took her head with
but the far more important point is a federal court that dismisses one claim, because as the Supreme Court has said, standing is not dispensed in gross. You have to have standing for each thing you're seeking relief on. And if one of the things you're seeking relief on is dismissed for lack of standing, the court is basically saying, I don't know if you're right or wrong, but I can't reach that. So that's not been resolved. I'm sorry for the long answer.
That's all right. I'm going to go back and ask the question again. You were aware that either President Trump or the Trump campaign had filed lawsuits in a number of the swing states, correct?
Yes.
And among the challenges were the same, like the signature verification, or some of the same issues, or the same issues that you raised in Texas versus Pennsylvania.
Yes.
Well, I know there was a Trump case in the Third Circuit, so Pennsylvania, and there the Third Circuit held that he didn't have standing to bring an elections clause.
But in a number of those cases,
He did.
the Trump campaign was found to have standing,
Right.
and the court ruled that there was no violation, or the states had not violated the electors or the electoral clause or done anything untoward in their signature verification and the other procedures that were in place for the 2020 election.
We have to look at a specific case, and I could look at the decision and get back to you.
So I guess my question is what, if anything, did you do before filing Texas versus Pennsylvania to familiarize yourself with the challenges brought by the Trump campaign, where the Trump campaign was found to have standing, and the resolutions of those cases?
Not sure that, okay, so this is the Supreme Court. Federal district judges sitting as a sole adjudicator lack authority to render presidential decisions binding other judges, even members of the same court. American Electric Power Company versus Connecticut, 564 US 410, 428, and that is was in the year 2011. So I guess what I'm saying is the sovereign state of Texas doesn't care if a candidate for office loses a case in district court. It's not binding against Texas anyway. It's just a district court decision. I mean, these things need to be heard, and they will eventually. So in 15 or 20 years, we'll know the answer to all these things. Can an administrator do this? Can a federal court do it? Can a state court? That'll all be known at some point. What we were dealing with in December of 2020 is what does, we had the Bush v. Gore concurrence. That's all we had. We have a little bit more now.
I'm going to go back to my question, Mr. Joseph, and that is, what, if anything, did you do to familiarize yourself with the Trump campaign's challenges to these election administration issues and the rulings of the court in those issues? And if you didn't do anything, that's fine. I just want to know, did you do anything to familiarize yourself with the challenges that have been brought and the court's resolution?
We were looking at some of the decisions, yes.
Oh, some?
Okay, what decisions did you look at, or did you review?
I mean, you should know.
I know we looked at the Third Circuit. I don't know where it was in the process then, but we were definitely tracking the Pennsylvania litigation on because I think it had started earlier, so it had gotten further along.
You lost that one too,
because they were still fighting. They were actually fighting about that before the election started. Before election day, I mean.
Wasn't that weird?
So I know we looked at that one.
That's kind of weird. Okay. And.
I mean, I could probably answer this when we get back, but I'd have to go back and look at some.
Where?
I mean, I don't even remember what happened when, but we certainly looked at some cases.
Wow, you're a terrible lawyer.
But with the caveat that I
don't want
mentioned.
You as a lawyer. You don't have any brain.
So what? I mean, you want to look at what they argued more than what they held, because they weren't the final decider.
Right.
So for you, it was a so what if the federal court had looked at these challenges and found them to be without merit?
It was more like a wargaming thing. I mean, that sounds so vicious or whatever. I mean, it was what are people arguing? Is we looked at briefs as well as decisions, because ultimately it's the Supreme Court that's going to decide what you can and can't do and who can and can't litigate it. And that's not happening yet.
And on behalf of the state of Texas, you sought to have the Supreme Court enjoin the 4 states that you sued, that would be Pennsylvania, Georgia, Michigan, and Wisconsin, from using their results to appoint presidential electors.
I forget what the relief requested was.
Well, in effect, you were seeking to disenfranchise the voters of those 4 states, correct?
I forget what the relief requested was, but there was certainly room to I think, I mean, I don't remember what we asked for, but it could have been sent back to the state saying, look, what you've done is illegal. So if you can fix, I mean, it's a Humpty Dumpty problem. If you can fix it, great. If you can't fix it, there's a process in the Constitution for when the election is indeterminate.
Oh, boy. And you know that every state has procedures for challenging elections, including recounts if a candidate would request a recount.
I need an Eastman picture. Hold on.
This is a federal issue and you're allowed to bring it in federal court. Yes, they do. I mean, I guess the answer to your question is yes.
And you're aware that the state legislatures have also enacted statute to provide for recourse or for election challenges in the state courts.
Yes.
Oh, here we go. This is a good one.
One of the pieces of evidence that you, I guess, cited was a declaration by a Charles Cicchetti.
I didn't work with Dr. Cicchetti, but that was it. That was in the document. Yes.
No, he's not.
Okay, and that was one of the things that you highlighted to the Supreme Court, I guess, in support of your claim that there was fraud.
Again, that was in the document. I didn't work with Dr. Cicchetti. That was not my part of the project.
Okay, I guess I'm having a little bit of trouble, Mr. Joseph, because you signed on to this complaint, correct?
You're using the verb sign, but I don't think.
Okay, you allowed your name and bar number and your status as an attorney to be included in the complaint as counsel for Texas.
I don't recall about my bar number, but my name was in the signature block. Yes.
Okay, and that was with your permission.
Yes.
Okay. And you read the complaint before you allowed your name to be included as counsel for Texas.
What is the relevance of this?
Just actually, if you read the complaint.
But I'm not being charged with anything from Texas versus Pennsylvania, so I don't know why that's relevant here.
Well, is he? I'm not sure.
Well, one of the things I think Joseph has said previously, and I don't know if he's going to repeat it today, is that when he was brought into the Gomer case, it was all last minute. And I'm trying to establish that he was very familiar with a number of these allegations and indeed had been counsel in another case where there were allegations of election fraud and all sorts of other misconduct. So he was very, very familiar with these issues.
The elections and electors clause.
The Texas versus Pennsylvania case involved procedures in Pennsylvania, am I correct?
No, it also involved Georgia, Michigan, and Wisconsin.
I love this.
And what about
just makes
the Gomer
everything
case?
fucking huge.
Did that involve the same states?
Gomer, the plaintiffs were Republicans who were electors for Donald Trump in Arizona, but there were also claims again about the swing states of Michigan, Wisconsin, and Georgia in the Gomer case, and Pennsylvania. Excuse me.
That's not exactly
the question she asked you about the Texas versus Pennsylvania case.
And so, what was the question?
We'll have to sort out its relevance.
Okay, so you were aware of Dr. Cicchetti's, I guess, the declarations that were cited in the complaint.
So funny.
I was aware of them. Yes.
Okay. And you were aware that, according to the complaint, Dr. Cicchetti said that it was a 1 in quadrillion chance that Biden had won the election.
You can move him over now.
I don't understand what he was talking about there.
Well, in fact, Dr. Cicchetti said that that's not what he said.
Okay.
Well, you're aware that Dr. Cicchetti issued an article afterwards saying he had never alleged that there was systematic fraud or any fraud, and that his statements have been taken out of context by Mr. Paxton?
Oh,
I mean, I understand that. Well, I don't understand what was in his declaration on, but I think there's a fairly good lineup between what's in the.
I need this to be
I don't know if it's a motion or the actual complaint. I forget where it lived, but I think the statements in the plaintiffs, that's the state of Texas's filing, align pretty closely with what was in the declaration. Now it may be that he didn't mean that a lawyer, not me, but working with him on the on that part of the case got him to sign something that he didn't mean to sign. But I don't think there's very much difference between what is in the signed declaration and the whether it's the complaint or the motion for leave to file the complaint, I forget, but or even but I don't know how that's relevant here. And I
gotta get this over.
I mean, if you look at what his declaration says, that's where the word quadrillion is in his declaration. It wasn't just planted in the lawyer's document, be it the complaint or the motion for leave to file the complaint. I mean, I don't know what he meant by that, and what I fear, because again, I'm an undergraduate math major, so it's a little dangerous because he's a PhD, whatever. But I hope he didn't mean, and maybe he did, was just some sort of null hypothesis thing, which assumes that, like that votes are uniform throughout a state. And so like if the Detroit vote comes in later than the rest of the Michigan vote, well, let's assume that they vote the same. Of course they don't. I mean, the Democrat Michigan, Detroit is a Democrat stronghold, whereas the rest of the state is less so, or not so. I mean, there are a few scattered around. So I don't know what he meant by that, but he signed it, and it's replicated pretty closely in the lawyer's documents.
Okay. Emily, could you pull up Mr. Cicchetti's I guess letter? This is a letter that is Academia Letters, April 2022.
Objection, that's not relevant. If you want to bring up the core documents, that's fine.
I'm just going to ask you about one statement. If you could go to page 2, Emily. This is a article or letter by Dr. Cicchetti, excuse me. And after footnote 7, which is on the first full paragraph, it says the declarations do not support what Paxton claimed about Trump winning, or the odds of this were overwhelming. And he's referring to Mr. Paxton, who was your co-counsel in the Texas case.
Objection. I'm sorry. I'm having a little difficulty in following all this. There's a lot of innuendo and statements of statements. I'm going to ask if we could have some documents and some certainty rather than throwing around asking questions that we're not sure exactly who's saying what.
I'm not sure I understood that, Mr. Byrne. What was you want to have what?
Well, I will confess to be confused. I would like if we could have the declaration that shown that Dr. Cicchetti signed, if we could understand exactly what declaration we're talking about.
Whoops.
And then we could match that up with this article of whatever date it is, I'm not sure, so we could have some certain testimony.
What I'll represent is that I recall that the Cicchetti declaration, and he says he uses plural here because there was a supplemental, and so declarations, I guess. The brilliant thing was in the initial filing, and I believe, and I would like to, as Mr. Byrne suggested, see what those documents say before we get into this sniping. I mean, this is a CYA kind of effort by Dr. Cicchetti, and I don't know what statements by General Paxton he's referring to. And if it's the complaint versus the complaint or leave to file the complaint, lawyer's document versus the Cicchetti declaration, I think they're pretty close as I recall. And I would like to look at that before I answer what he might be sniping about here.
Okay, I'm not sniping at anything. I'm
sorry. I didn't mean to say that you were. I'm saying that Dr. Cicchetti is.
Oh.
Okay. But whatever statements Mr. Paxton made in the Supreme Court filings, you were also listed as counsel in those Supreme Court filings.
Absolutely. But this document that's here on the screen doesn't say where General Paxton was speaking. I mean, if the Cicchetti article or letter that you've got up now is talking about the difference or the statements that General Paxton made, I think he was the counsel of record in the motion for leave to file a bill of complaint, then fine. Then this is Cicchetti's opinion about that instance. But if he's talking about something else, a different statement, I don't.
Okay, you can take it down, Emily. But just to be clear, whatever Mr. Paxton's, I guess, had submitted had your name on it with your permission, correct?
Yes, my name was on all the Supreme Court filings in that case with my permission.
And your endorsement? Yeah, obviously.
You know who Texas and Pennsylvania TV worked with Dr. Cicchetti?
Yes.
Do you know if that person talked to Mr. Cicchetti about the content of the declaration?
Yes.
Are you aware that Dr. Cicchetti expressing reservations at the time about the use of this declaration in connection with the motion for leave to file?
Absolutely not.
The Supreme Court denied your motion to leave to file the complaint approximately 3 or 4 days after you filed it.
Did he know that the doctor he had relied on for information had disavowed
and within
that
2 weeks or less than 2 weeks, you had agreed to represent the plaintiffs in what we're referring to as the Gohmert litigation, correct?
Yeah, whatever about that same. So I think the Texas was dismissed on the 11th, if I recall. And so then there's the 22nd is I was contacted. The 25th is when the case got green lighted in Texas, and it was either the 27th or the 28th that I agreed. So within less than 20 days for sure.
And you obviously knew about the decision in Texas versus Pennsylvania. But you are also aware that Ms. Powell and her team and Mr. Giuliani had been filing and losing cases on a variety of fronts, correct?
That's right.
You also knew that no court had found any evidence of fraud or misconduct that would provide a basis to overturn the results of an election in any state.
I really want to interject there. Fraud or misconduct by who? By the election officials?
By anyone.
By anyone, well, including voters who may have misrepresented their.
That would change the results or that would provide a basis to overturn the results of an election in any state.
All right, that wasn't the question you asked. Can you rephrase it and include that?
Sure. You were aware that no court had, well, and we'll kind of put a date on it, on December 27th, when the Gohmert case was filed. You were aware that no court had found any evidence of fraud or misconduct by anyone that would provide a basis to overturn the results of the election in any state.
Okay, so I guess two things about that.
Well, Mr. Joseph, if you would first answer the question yes or no, if you can, and then explain your answer.
Okay. But yeah, that's true. Trump had not won yet, and he still hasn't.
Litigant had won. Okay.
Yeah. So the I'm going to answer about fraud, then I'm going to answer about the Electors and Elections Clause and Article 3 and standing. Fraud needs to be played with particularity, and in these state election procedures, in the sort of week, 2 weeks, a month that's available, especially for some of this complex computer fraud, there's just not enough time to do that, and so the various litigants made the decision that they would not
ask John Eastman
pursue fraud. Like I think it was on the news. I wasn't really all that involved in watching. I mean, I was experiencing the news as a citizen. I wasn't really participating at all as a lawyer. But it was, get on the news that, they say they're not arguing fraud. And the reason they say that is because they can't plead with particularity. What Gohmert was geared towards, because there were anomalous results. I guess like Trump did pretty well, except in some counties. And as I mentioned with Dr. Chikeni, well, some counties are more heavily Democratic. So there might be a statistical explanation, or it might be something untoward. And anyway, what Gohmert was geared towards was these guys, or men and women in Congress, say they're going to challenge these votes under a 1887 statute that provides a process for dispute resolution under the 12th Amendment, alongside the 12th Amendment, actually. And there's a problem with that 1887 statute, which is that they rely on bicameral resolutions, which were fine then, according to Congress at least. And the Supreme Court, about 100 years later, in 1983, INS v. Chatta, said, no, that's not fine. That's unconstitutional. You can't have the two houses make a decision that creates some law. The Constitution says you got to have bicameralism and presentment. And if you don't get, the president's signature, you can override with the supermajority. And so that's one thing so Rule 9B of the Federal Rules of Civil Procedure don't apply to Congress. They can say, you know what, that's BS. There's no way that you would win this much in most counties and lose that much in that county, especially if you look at whatever happened in 2016. A member of Congress is allowed to think that. And I hope all our elections don't degenerate into that. And so I'll close about Band-Aids in a moment. But so Rule 9B doesn't apply to members of Congress. And so they could think there was fraud. And the fact that the plaintiffs in these other cases didn't try to prove fraud because they didn't have the time to get discovery and plead with particularity. That's one. Two, on the Electors and Elections Clause, the rule was, I don't think there was any that reached. Well, let's put it this way. Maybe there was a court or two that allowed an Electors and Elections Clause claim to go through. Then that wasn't dispositive. There are enough dispositive numbers of votes parked in states where an Electors and Elections Clause issue was not reached for it to swing a difference. You only need 3 of those swing states and the election changes. And similarly, Article 3 of the Constitution, which says what a federal court can and can't do, doesn't apply to the Article 1 or Article 2 branches of government. So the fact that no court, no plaintiff had won is kind of irrelevant to whether a member of Congress who equally swears to hold the Constitution says, no, I'm sorry, you like unmanned drop boxes? Wisconsin law doesn't allow that. And there's been 2 Wisconsin Supreme Court decisions, one 4-3 that says you cannot do drop boxes, and then they had an election and swapped the judge. And so now there's a 4-3 decision that says that you can do unmanned drop boxes. It seems inconsistent with the statute to me, but that's Wisconsin's business. But the point was, when we were sitting there in December or January of 2020 or January of 2021, it looked like maybe they were breaking their own state election law. And they're not, and that's not just a election challenge under Wisconsin law. That is a violation of the federal constitution. There was no right under the states as they won their independence from England. There was no right to nominate the president by any means, any possible, there was no president to nominate. So that's a creation of the federal constitution, and it is a federal violation that
why don't we ask
that had not been reached in enough in a dispositive number of states. The last thing I'll say about this is, so I'm probably a maximalist on the electors and elections clause, and we're going to answer someday. I mean, there was a little bit of a setback in Morby Harper. The court there, the U.S. Supreme Court said that, well, actually, the electors and elections clause said that the legislatures thereof shall pick, but the state Supreme Courts can they have room to operate under that umbrella and still be a permissible deviation from what this legislature wanted. We still have to decide about federal courts. Morby Harper left open the instance where a state Supreme Court might be able to do something, but there might be ones where they can't. And then there's the issue of state executive officers, like secretaries of state, what have you. I find it disturbing that you have this sort of pre-election litigation to basically weaken the structures that the legislatures are put in place. Some of it, I believe, by bodies of decision makers that are not allowed to do that. But that remains to be seen. We're living through Bush v. Gore was 2000, Morby Harper was 2023. It still hasn't resolved most of the issues. So I think that what Texas tried to do in the Supreme Court and what Gomer tried to do, basically by focusing on the vice president, is to say, look, we're not going to allow, if you're cheat like that, we're not going to be counted. It's an illegal vote. You won't never won legally. And so that would stop it. That way, Martin Lyons would have to start doing other things if a court said, I'm sorry, you're saying, oh, it's important to have elections and democracy and all that. But if they're doing it by illegal votes, that's not really democracy, because there's two sides to the National Voting Rights Act. One is we want to have the most number of people vote, and two is we want to have legal votes. And if those are inconsistent, that's a problem. And that's, people say that they're trying to save democracy as though the other person is trying to nullify it. That's not what's going on. There's different visions of democracy. And your question sort of goes to one side of that, but I think there's another side that's equally valid.
Sure,
I'm done.
That was a very long answer too.
I don't think it was responsive to my question, but I do want to pick up on one thing that you said, and that is about the pre-election contest. So in your mind, it's not okay to challenge a procedure before an election and get a definitive ruling, but it is okay to challenge a procedure that's been in place sometimes for years after the election, after everyone has relied on it because your candidate didn't win.
That is the Bill Martin problem. I don't know if so Bill Martin famously ran out of the. He knew that someone was using an illegal bat. He waited until he hit home run to run out of the dugout and say, "I'm shocked. He's got an illegal bat," and that wasn't allowed. So that's the equity thing that you're getting at. Did they? I thought they. Yeah. Really? Oh my gosh! Wow.
Okay.
Oh my goodness!
Shit about your fucking baseball bullshit.
Wow. I stand corrected.
Wait, you did identify the issue correctly.
Just
wait until George Brett hit the home run, and then he using the bat.
Okay, I'm not appreciating
right.
this.
Okay, so
this is fucking democracy. Take it fucking seriously.
Don't
you see me taking all of this seriously?
You say definitive ruling, and I guess I disagree. If you, what I think a federal district judge should, like for example, the Georgia settlement. If a federal district judge thinks that because of a COVID problem, that the verification is too stringent or whatever, the federal judge should say, I'm going to enjoin this, and the plaintiff can go to the legislature and try and get them to fix it. And if they don't, then I'm just not going to allow absentee voting, and not allow the expansion of absentee voting. The legislature says you can do absentee voting, but you got to do witness requirements or whatever it was, or signature verification. You can't. A federal judge doesn't have the power. The federal judge has a pen and a typewriter and all that, and he can sign the order, but that doesn't make it legal. And I don't know that you'd have standing to challenge it until after the election, quite frankly. But, but that's not even an issue in the Gomer case.
No,
Because Article 3 doesn't
You still
bind
haven't
members
answered
of
the
Congress.
fucking
The point is,
question.
they were going to challenge the votes to count, and the process they had to do it was illegal. And Louis Gohmert was going to either vote in an election in the House for president or not, based on the outcome of that case. And that's
based on the outcome of which case?
What case?
The Gohmert case.
What?
And so that's a concrete injury. So he,
What?
I mean, because what they say about standing is, you know, it can be a trifle, any trifle, but you have to have
we arguing
personal
the standing
stake.
of the
You can't
Texas
just have an
case?
interest.
Okay,
You
and I'm going to
can't
get to
the Gohmert
standing,
case?
and I guess I'll leave. Do you have a question or?
No, go ahead.
Okay,
If you could keep your voice up, that would help.
okay, sorry about that. Let me ask you a little bit about what you knew about the plaintiffs in the Gohmert case before you agreed to have your name listed as plaintiff's counsel. You knew that some of the clients, your clients, the plaintiffs, had previously filed a lawsuit in federal court in Arizona to overturn the results there, correct?
I knew that.
And you knew that they had not been successful.
And on the electors and elections clause, they didn't have standing.
Oh my
Okay,
God.
and I'm going to get to that. You knew
erection
also, because you
clause.
talk about these other swing states in the Gohmert case, so I want to go through those too. You knew that there was also an election challenge in Georgia to overturn the results of the election, and that had not been successful.
And there too, I believe there was a standing problem.
And you knew that there had been a similar challenge in Michigan, although that case had not been finally resolved. Judge Parker made it pretty clear, order denying preliminary relief, that the plaintiffs were not going to succeed.
And on the electors elections clause, there was no standing. And again, some of these were on appeal too. They weren't over.
Okay, well, I'm going to get to some of those. And in Wisconsin, you also knew that there had been a
Honey, she did her
challenge.
homework, all right?
And
bitch.
that had not to overturn the election, and that also had not been successful.
I was never as familiar with that case as I might be. And maybe it was also that I think the things that people chose to litigate weren't the best of issues, but go ahead.
Okay, well, you know that Ms. Powell,
Which
Ms.
one?
Fowler, Mr. Johnson, Mr. Kleinhelder had been involved in litigation in Wisconsin on behalf of a Mr. Feehan.
I don't think there's a foundation for saying my client was involved in Wisconsin litigation.
Well, do you want me to show you the complaint? I can pull up the complaint.
No, I'll stipulate that her name is on it. You
Okay.
said involved.
Oh, please.
So their names were on a
She go
complaint
around
and
signing
listed as
shit?
plaintiff's counsel.
What I
What kind
would
of
say
fucking
about,
lawyers are these?
First, I didn't know Julie Heller, Brandon Johnson, Harold Kleinhen. I didn't know they existed until December 22nd. I knew Sidney Powell and Rudy Giuliani because they were the people that were on the news, and I was experiencing this not as a lawyer but as a citizen.
Really?
And so I knew that they were, out there losing lawsuits.
And one of the lawsuits was
What?
in Pennsylvania.
You did?
Yeah, that one I knew about because of the.
Emily, if
But
you
you
could
didn't
pull
know
up
about the other ones?
Mr. Joseph.
Yes, I could. What I knew about Pennsylvania had more to do with, I think it was the Republican Party in Pennsylvania, and I'm sorry, and the legislature, because at that point I think they had a
Botoxes.
Republican
Which one?
majority in both
Clarence?
houses, and they were fighting over what the
John?
deadline was, and so that was I was involved with that.
Yeah,
I
baby,
really
you're
don't know
involved. Your
who
name's on it.
between Giuliani and Powell
got paid.
and Trump was suing in Pennsylvania. I wasn't really following that. I did follow.
Follow the money.
I don't know the dates about what happened when, but I did follow
Why don't we do
I guess the
that?
Trump campaign's litigation in the Third Circuit.
Are you
But I
supposed
don't
to?
know. Remember
I have a
when that
serious
happened.
question. I'm going to stop it for a second. I have a serious question. Do you have to, or are you required to disclose who pays your legal bills? Is that ever a requirement? I'm just wondering.
Okay. Emily, would you please pull up Mr. Joseph's exhibit number 8? This is a document, email chain that's familiar to you, Mr. Joseph?
Yes.
Okay. And Emily, if you could go,
Howard
I think it's in reverse
Kleinfeldler.
chronological order. If you could go to the
Kleinfeldler.
second page, please.
From Brandon to Howard Kleinhandler.
So, Mr. Brandon Johnson, do you know what his affiliation was with either Ms. Powell or Defending the Republic?
Attached for review and comment is the draft of the DC District.
Okay, so I'm not on this
complaint for
email.
declaratory
Okay.
and
No, I
injunctive
didn't
relief in the
really at
12th
that point. On the
Amendment and
22nd,
finding
I think Howard
Electoral Count
Kleinhandler
Act
called me, introduced
unconstitutional.
himself
That's
as
what it
someone working with
says.
Sidney Powell, asked if I'd be a local counsel.
Oh,
And I didn't really look at the name. I mean, I might have
yeah, I
seen the
would
names,
imagine,
but
right?
I don't, what's the question about?
Oh, he.
I became aware of it
There's
later.
there's
maybe
not
later
enough
that day,
rats
but
in
I
the
didn't know who he
world to
was at
give
this
him
point.
rat poison on that
And
one.
this is an email chain where you're later, I guess, looped in. But according to this email, Mr. Brandon Johnson is attaching for review and comment the draft of the DC District Court complaint for declaratory and injunctive relief, raid the 12th Amendment, and finding Electoral Count Act unconstitutional.
Yeah. Do you see that
That's
one?
what that email says.
Okay, let me ask you about some of the other people. You said Howard Kleinhandler, had you never even spoken to him before December 22nd?
No.
Wow.
Never even spoken to him. How
Okay.
about Sydney Powell? Yes, you've spoken to her. Ms. Haller?
No.
Okay.
Okay.
Who is Peter Haller, if you know?
Hillstrat.com.
Was brought, but I studied him briefly. He's into the emails, but he obviously wasn't on the case.
Do you know if he's a lawyer?
I don't recall. If I had to guess, I'd say 60-40, but I don't recall.
Oh,
There were also some statistical people involved, and so I just don't remember.
Oh, okay. Well,
But did you talk to him about the complaint in Gomer before it was filed?
I remember like statistical conversations with someone. I don't remember who.
Oh, okay. You don't remember?
I talked with Peter. I don't recall in what context. You know,
Okay.
number versus statistical.
Okay, and there's two
Interesting.
more people, E. Newman, I think it's Emily Newman.
Oh,
I never dealt with it was possible I did.
it's possible I
think
did.
so.
And A. Fry, do you know who that is?
Yeah, that's Abby Fry or Abby.
Oh, at the
and
Banal Group?
she
Oh.
was not. Oh my goodness, she's a
Jessie
I didn't
Banal?
know that she worked there even. She works with Sunny as a sort of Sunny Powell, I'm sorry. Sort of a right-hand person as
Really?
opposed to, you know.
Is she related?
I
Is she
never,
related to Jessie Banal?
dealt with Ms. Fry as when legal issues that would end up in a booth. It's more like coordinating Ms. Powell's schedule, what needs to happen. I mean, I don't really know what Ms. Fry does. You'd have to. I believe perhaps
Where's Harvey?
Mr. Johnson or Ms. Haller might.
Hold
They were
on.
perhaps closer to that organization than I was.
Okay, do you know if Miss Fry is a lawyer?
Yes, she is.
And Emily, if you could go to the first page and start towards the
Sure.
bottom. And this indicates that Mr. Kleinhandler, excuse
Well,
me,
what do you
is
know?
sending Mr. Johnson the complaint back with what I assume Mr. Kleinhandler's changes are on red line. And then it's please get us your comments, if any, in the next couple of hours. We want to file today. And are you copied in on that? No, you're not copied in on that. And if you could go up to the next email.
Well, fuck me.
And this is when you're copied in, Mr. Joseph?
Why,
Well,
that
well,
happens
yes
to
and
be
no.
where
They
Mr.
spelled my first
Jessie
name wrong, so that-
Banal
I
is
believe that email got
also
rejected. Not my first name, I'm sorry.
employed.
They spent that before the ampersand part of my
Isn't
email.
that
It's
interesting?
Jazpay instead of
My
Joseph.
Lord, that's so
Okay,
very
but you did get this
interesting.
email because
I think if you scroll up further.
I find it
Maybe-
so very interesting.
Is that the top?
Why, there it is
yes,
right
I
there.
believe so.
No, I did not get this email. Okay, there's more. Is there?
Harvey
I
Banal,
got this chain eventually.
LLC.
Well, you produced it as part of your
Jessie.
exhibits.
Well,
Now-
so up, brother.
There's
Yeah.
Jessie right there. I don't know who Adriana or Ariana or whatever her
This is
name
what I
is.
got. This is L Joseph at
She
LJoseph.com.
might
The
be
other one was
not,
L Joe's Pay.
not one of the partners.
But you did receive an email from Mr. Klein.
This, yes.
Yeah. And what you received as an attachment
Well, that's
is
sehr
the complaint that Mr.
interesting.
Brandon Johnson had circulated and that Mr. Kleinhelder
Sehr
had redlined,
interessant.
correct?
Sorry, I'm talking over it.
Yeah, I got the result. I don't know who did what.
God,
for
this
that.
is so interesting.
Well, if you look at the, Emily, if you could scroll down a little bit just to show Mr. Joseph
Jessie
what was
Banal,
included in his
lawyer
exhibit.
of Mike Flynn. Jessie Banal's lawyer to
This is the attachment, or this is what you included in as part of
the
your exhibit. So
stars.
am I correct
lawyer to the
that
stars.
the exhibit, the nature of the action,
Excuse me.
Crybaby
counsel, can I
lawyer.
ask, that's, would seem to be attorney,
Client privilege.
client, privileged or
I don't
work
care.
product. I don't know if there's been a
What?
waiver of that, but, I'd like to get that established on the
What, is
record
it
if
a
that's the
draft?
case.
there's no communication with the client in there. I would think it's something between Mr. Johnson, Mr. Kleinhelder, and Mr. Joseph at this point.
Oh, that's a work, I'm not quite sure what you're showing here. I said a privileged and work product. That I think clearly is work product.
Well, so it's been waived to the extent that Mr. Joseph has produced it as an exhibit, and he produced it, I think, about 2 months ago.
Oh,
I'm
shit.
just asking if he's had, if that waiver is pursuant to any kind of a permission. I mean, I don't know. If
It was
it's
submitted, it was submitted by one of the respondents.
unauthorized waiver. I don't know.
May well be, I wouldn't
Well-
have permission to do this.
In a
Tough shit.
disciplinary matter, you can, pursuant to 1.6, use attorney-client privilege to the extent necessary to defend against the charges.
I'm just asking if it's been waived, that's all. And that's a simple question. I think the record deserves to know that.
Oh, you're panicking, bitch. Let's be real.
Why don't we hold up on this until we've had a break? We'll discuss it among ourselves.
Let's call
The claim
some
is that
shit,
this-
some shit. Oh.
Well, it's certainly not your work product, is it, Mr. Byrne?
I'm just raising the question. I mean, disciplinary counsel raised an attorney-client privilege
I'm
with
just
Mr.
asking
Thomas the other
questions.
day. It certainly was not her
I
affair.
don't,
and
I don't know
just
how
thought that,
any of this works.
This is obviously work product.
Right,
I'm not aware of
that's
any waiver. I was just asking
That's what
for any
I'm
kind of a
saying,
proffer,
because
if there's been a waiver or what. I don't know what the status
It's
is.
got blue lines on it, and that's.
I'm
And
almost
there's
certain
an
this is something
AI
that could
assistant
probably
in
be
the
inquired into, but
corner.
give
This
us a
is
moment when we
completely
take a break. Can you come back to this?
Yeah, I won't look at the actual document. I'll just look at the emails, if that's all right. I can ask him about the emails. You can scroll back up and will you please to the emails?
I don't want to talk about it.
So just to confirm, Mr. Joseph, the
didn't
emails
look at
reflect that
discovery,
Mr.
Your Honor.
Brandon Johnson circulated a draft 12th Amendment complaint to DC District Court, and you received a copy that had been redlined by Mr. Kleinhelder. Is that correct?
Yes.
And are you saying that you just received this out of the blue with never speaking to Mr. Kleinhelder?
I thought I said that he called first.
Okay.
He called and said, I live with Sydney Powell. And like I said, I've had a good experience with her. So I, looked at it.
And he sent it to you. At that time, had you agreed to represent the plaintiffs?
No.
Okay, so Mr. Kleinhelder was providing this to you, the draft complaint, without first getting some sort of, I guess, consent from you that you would represent the plaintiffs.
Correct.
Just if I could interject.
Again, I'll note the objection. I mean, when when someone consults an attorney before an engagement, anything that's transmitted there is considered privileged, and I would wonder whether this was the same situation. But again, if the chair is going to be considering that, I think that's something that should be considered.
Well, that
Let me
horse
just say,
left
this
the barn, so
Email something that was
I'm so
produced to
sorry.
the ODC during.
I know that the emails were, there was a lot of paper produced to disciplinary counsel. It probably was, but I can't tell you for certain when it was. But I know that Mr. Joseph has included it in his exhibits that were, I believe, filed on August 12th.
Fucking submitted it. It's one of their exhibits.
Yeah,
It's
but I was
not
going to ask you, Mr.
a process,
Joseph.
or it's not
So
a
Mr. Kleinhandler was the first person that contacted
bar
you about
exhibit.
being an attorney in the Gomer case. Am I
Right.
understanding?
It wasn't even Gomer then. It was, he wasn't involved. But yes, this
Oh, okay.
what became the Gomer
Well,
case.
that's
Yes.
Right here, they talk about the DC District Court. That's not where Gomer was eventually filed.
Correct.
Mhm.
So,
Right.
but is what evolved into the case in Texas.
Mhm.
All right. And did he give you any idea? Did he just say, we want you to work on the case, or did he give you some specific idea of what you were to do?
Well, they wanted a local counsel. They wanted to file in DC.
Oh.
And I think, I don't, I do have an email with Sydney on it, Sydney Powell on it from October. And so I might have been top of her mind. And that was from the Stockman case I mentioned earlier. And so maybe she said, oh, I know they're in DC, or maybe it was because I was on the Texas versus Pennsylvania. And they said, oh, let's get that guy. I don't know why
let's get
they
that
contacted me. But this is the first I heard of
He'll
it.
do anything
All right. And then when Mr.
for a
Kleinhelder
buck.
contacted
Kleinhandler.
when he contacted you, again, did so originally you were to be local counsel in DC. Obviously that was no longer the case after they decided to file in Texas.
If I may, I can respond to that. There was a case filed that same day in DC on it was a blunderbuss of a complaint, but it included this issue. And so it seemed, so what I told him at the end of the day was, this was in the morning, I think. Yeah, it was a late morning. I told him at the sort of close of business 5-6 o'clock-ish, I think, that, so-and-so just filed a similar case in DC. There's no point in filing in DC. You'll get the same judge. You're not going to accomplish anything by bringing this in DC. And at that point, anyways, that answers your question, I think.
All right. So at some point they decided to retain you to help with the Texas case.
Right. I guess I had other comments or whatever. So they had me tag along when they reoriented.
And did anybody, either Mr. Kleinhandler or Ms. Powell or anybody else tell you what they expected your role to be, what kind of work they wanted you to do?
Well, figured out that sort of Howard was kind of the
I
boss.
just knew I was going to be
and,
clothed, Your Honor.
Yeah, I mean, it was just,
I'd stipulated no nudity.
I mean, I was,
They
do what they told me to do kind of thing.
What did they tell you to do?
Yes, we're in
Comment on
DC,
this, comment on
Lee.
that.
Oh, it's been good.
I'm not sure that I understand the question, to be honest. It was just held out.
What they asked you to do?
There was no specific, I'm sorry to interrupt.
Did they give you any specific instructions at any point as to what you were to do?
I was a subordinate and I would do what I was told, on an ad hoc basis.
Okay, can you remember any specific assignments you were given?
I mean, it was more generic, like comment on this,
Really?
this, help us with this. I mean,
Right.
and so
Hold
I mean,
my
I
hair while I
I think I
vomit in the
took,
toilet.
again, it was
That kind of
subject
thing.
to Howard was the boss, and then under the rules of the Eastern District,
Mm.
there was only one Texas counsel, because Ms. Powell, I think it was remarked earlier, was not on the complaint and was not involved in the district
Oh,
court.
baby. Okay,
Um,
I'm going to say something.
She was
here.
involved in the
Hold on.
appeals, but so the only Texas
Hold on.
lawyer on the,
Darling, I'm stopping you for a minute. To Mr. whatever your name is, Larry Johnson, I don't know what your name is, Larry Howard, I don't know. Whatever your name is. Kenny, let me call you Kenny. Flip on Sydney. Flip on that bitch like a pancake. Flip, flop, till you don't stop. Okay? That's my advice to all of these morons sitting in these courtrooms. Just fucking flip. Because Sydney would take a shit in your face if somebody said that would make everything bad she's done go away. Okay? I'm telling you, like, please, stop being so fucking stupid, Tina Peters, and flip on people. Right now, Patrick Byrne is on the run in Dubai because he knows that he has broken so many laws and financed so much seditious conspiracy that he will probably be found guilty of treason, like the bad kind. And I am trying to say to these morons who sit there and like spout this bullshit, just fucking flip. Flip on Sydney. Flip on her. Flip, 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 flop. All right, here we go. Sorry. I mean, please, come on, somebody, grow a brain.
the filing was Lewis Sessions, and
I
under
know.
the rules there, you can't do anything. Even if you get pro hoc in, you can't do anything without his approval. So it was, within the constraints of working collegially, do what they say.
All right,
Wow, so you're like the
think I
world's
kind of
worst
understand.
lawyer.
go ahead.
Thank you. You refer to yourself as a subordinate lawyer, yet
No
you've been a
memory.
lawyer for almost 28,
No-
29 years.
No structure, no nothing.
Howard was the boss. Lewis was the lead counsel. Yeah.
And you were also brought in because of your, I guess, experience in constitutional law issues, correct?
You'd have to ask someone else. I don't know.
Well, do you know what, if
I know
any,
what I know.
constitutional law experience Mr. Kleinhandler had?
I don't.
No, I never asked him.
Well, if I could, they would come up with a complaint, and one of the things I haven't done,
Never
what I need to
looked at the
do
CV.
is take that Word document, accept all the changes, and then look at the final Word document and compare them to see what changed. I'm curious. And, we'll look at that at some point.
This guy's
Okay, when you say
talking.
they
I
put
mean,
together
I'm
that
at,
complaint,
I'm
that
at
would
one
include
and a
Mr.
quarter
Johnson, who
speed.
circulated, I guess, the draft to Mr. Kleinhandler
Yeah,
and the rest
I'm
of the
still at
people?
one and a quarter speed.
Greg didn't send a word. I don't know who put it there, but it came to me as it came to me.
Okay, and Ms. Howard was included in all those emails as well, correct?
I only have up to the one that you showed. And I don't know what, I don't know,
Maybe.
at the point that Howard said he has a complaint, I mean, it could be that someone else, entirely unbeknownst to us,
Could be.
drafted, to me at least,
Could be totally
drafted the whole
someone.
thing and all the other,
This is
that sort of
stranger.
3-tier of here's some edits, here's some edits, here's some edits. Those could have been split infinitives and the like. Someone else could have done the whole darn thing for all I know. I mean, my window started on the 22nd and that window only reaches back so far. And I don't even see the drafts from the Brandon email that you mentioned at the foot of that tree. So I don't know who did what, when, where.
Okay,
Well,
but when
yeah, I
the
don't
complaint
know
was
anything.
eventually filed,
I don't know
there were
anything.
5 lawyers listed as plaintiff's counsel, and that included you, correct?
Me? What? Me?
Um,
Oh, no.
With the caveats about who's, what is a counsel, but yes, it says that at the footer and the names are there in the signature block.
And that included Brandon Johnson,
Yes.
correct? And that included Julia Howard?
Yes, both of them with the same
Mr.
caveats.
Yeah.
Okay, and Mr. Kleinhelber?
Yeah.
Yes, and with the same caveat, because I would say he was the boss, but he too, in some ways, he was like Julie Heller, Larry Joseph, and Brandon Johnson, but he was actually, Lewis was the lead counsel, he was kind of the boss.
Oh, okay.
So your contention is Mr. Sessions was the lead counsel?
He
Boss
absolutely
under the
was, under the
boss.
local rules.
Okay, well, I'm going to get to Mr. Sessions in just a second, but just to I guess, close the loop, this was initially going to be filed in the United States District Court for the District of Columbia.
That's my understanding, yeah, that's what.
And it was you who suggested that they file it in another forum because the case of Wisconsin Voters Alliance versus Pence had already been filed or been recently filed in the United States District Court for the District of Columbia.
That is the case that I remember. I don't know when I spotted that. I might have gotten an email about it, or I don't know how. I think it was filed that day, if I recall correctly.
Okay, but you're the one who raised the issue and suggested that they file it in another forum.
I think I suggested, yeah, maybe, but I certainly suggested don't file it in DC, would be a waste of time.
Me?
Okay,
I say
and
that all the time.
I think you said
It's like
before
a
that,
tagline.
who brought Mr. Gomer in?
I don't know.
Okay, well, someone brought Mr. Gomer in. I mean, the reason that Mr. Gomer was brought in is so you could file it in Texas?
Maybe.
I assume what you just said is true, but I really wasn't in that loop. It would have been either, well, I don't know. I was gonna guess that it would
I think
be
I was getting my pedicure.
Powell Kleinhendler, but I really don't
I
know.
missed that meeting.
But you knew that Mr. Gomer was going to be among the plaintiffs by no later than Christmas Day.
That's right. I believe I learned that on Christmas.
And that gave you and the rest of your team the ability to file the lawsuit in the Eastern District of Texas.
Yeah, maybe. I don't know.
Yes.
They did it. I didn't have anything to do with it. I don't even know where Texas is.
You knew Mr. Gomer because he had filed an amicus brief in your Texas versus Pennsylvania case, correct?
Well, I knew his name as a sort of
yeah.
someone who reads the news, but I didn't know him.
I know.
And Mr. Sessions, am I correct? That there wasn't a determination that it was your Gomer case was going to be filed in Texas until Mr. Gomer was brought on Christmas. So that means Mr. Sessions was brought on sometime either Christmas Day, the 26th or the 27th, correct?
Objection, there's been no foundation that he can either knows or can follow disciplinary counsel's conjecture.
If you can't understand my question at any point, Mr. Joseph, please let me know. I know that I'm not always clear, and I will try to break it down or rephrase it. Do you understand my question about?
You asked when Lewis Sessions came on, and I would assume that it was after Lewis Gomer came on, but I don't know when exactly.
Okay, and who made the arrangements for Mr. Sessions? Oh, sorry, I'm sorry.
I call him Lewis.
I bet if I went back and looked at my emails, I bet I could answer that, but I don't remember whether it was Christmas or the 26th or whatever.
Okay, but you were aware at some point that Mr. Sessions was going to be brought on, and I'll call him local counsel. Is that a fair representation? Because he was the lawyer in Texas that was going to do the physical filing of the complaint?
That's a fascinating question. The local rules are pretty clear that he's the lead counsel. And again, I have some experience with this with different district courts, and some the local counsel is just like a passport stamp. And once you get, and then your client or whatever, because most of my clients are lawyers, be the heads of associations or NGOs or whatever. And so I've had instances where I pro hoc someone in, and then that's the last thing I do, and they run independently. I believe the Western District of Michigan would be like that. Other courts, the local counsel is responsible for the documents, and the person they're in this instance a client. But whoever the other counsel can get locked in, but they can appear on papers, but it's the local. What we're calling the local counsel is not a rubber stamp. He is the stamp, or she. And so I think the Eastern District of Texas is one of those places, unlike Michigan, more like say Northern District of California, where he's not the local counsel, he's the lead counsel.
To your knowledge, Mr. Sessions, to your knowledge, didn't do anything to prepare or edit the brief or the complaint before it was filed. Is that correct?
I don't think so. I mean, imagine he would have looked at it. And he had some election experience, as I recall, as well.
Okay. Do you know if he did anything to make any changes, any edits in the complaint that he was presented to file before it was filed?
I have no objection to you calling me back after today, and I could try and find that out, but I don't recall. I imagine he did, but I don't know. I know nothing that's material to what you're, I mean, during the process, he was very involved and had edits and suggestions, and he was not just a potted plant kind of local counsel.
The other plaintiffs in the action that you filed in Texas had all been plaintiffs in Bowyer versus Ducey?
That was my understanding. I never actually checked the names.
Okay, well, you did know of the earlier case that these plaintiffs had filed in Texas?
That in Arizona, you mean?
Yeah, excuse me. Yes, in Arizona. Thank you.
Yes.
Okay. And you knew that they had been represented by Ms. Haller, Mr. Johnson, Ms. Powell, and Mr. Kleinhepler.
Objection, there's no basis in the record to show or foundation to show that they quote were represented by these people.
If I could say Team Powell, then, I would say yes.
I guess I want the record to be clear, and let me have you, Emily, I'm sorry, could you pull up exhibit number 224?
Go too far into this, and you have to do what you want to for the record, but I didn't know Brandon, Howard, or Julie with their involvement. It was a Powell case from Arizona. That's what I knew. If you want, obviously.
Yeah, and Emily, if you could go to exhibit number 224 at page 53. Yes. Okay. They're listed as counsel for the plaintiffs, correct?
Yes, I would never have seen this document.
That is not correct. They are listed as of counsel.
I'll second that objection, and I would ask that we make some efforts to keep that straight, because that's fairly obvious from the exhibit itself.
Yeah, I mean, the complaint says what it says. It's
Okay.
the best evidence of what these people,
Were you,
what their status was.
Oh my
okay,
God.
were you, okay, I'm sorry.
You had a question for Mr. Joseph based on this document?
You knew that they were involved in the Bauer versus Ducey case, correct?
I knew what City Powell was, and I gathered that they worked with. Actually, when this case started, that they were that pretty close to the beginning. I was picked up a little later, but we were all apparently around without. I mean, I assumed that they had worked with it for a long time when I met them through Gomer. But I learned it just early on the opening day that was not the case. And at this point, I would not have known that they were involved, but it wouldn't have surprised me. And then over the time, I got to, like I said, associate them. I thought they were sort of more deeply involved with Powell and her efforts, but I didn't really know.
So what did you learn about Mr. Johnson's involvement with Ms. Powell?
Well, he was out counsel with DTR, and I assumed that had been of long standing, but I was wrong apparently about that.
Okay, well, how are you wrong?
Well, I think earlier, if I recall correctly, from the opening statements, I think it was that he joined in like November or something. So,
I believe that was Ms. Haller who.
Okay.
Okay. Do you know how long Mr. Johnson had worked either for Sidney Powell or her organization Defending the Republic?
I don't, but I got the impression from oral argument or opening statements rather, and I must have been wrong, that they both were relatively recent.
Do you know what Mr. Johnson had done before working with Sidney Powell or Defending the Republic?
I think I heard it during the opening statements, but I forget.
Wow, you are really
you
bad.
Did you familiarize yourself with your clients? And I'll refer to the Arizona Republican plaintiffs in the Gomer case as your clients. They were your clients, correct?
That might be a hard question, but I certainly owe them the duty of confidentiality. And I mean, they were my clients in that regard, but I never spoke with any of them.
But you were counsel for the plaintiffs and they were the plaintiffs.
Right. I spoke with Mr. Representative Gomer several times and exchanged emails, but I did not even have contact information for the Arizona plaintiffs.
Who was communicating with your clients, the Arizona plaintiffs?
I have no idea. I assumed Howard was a Howard thing, but maybe someone else was doing it. I really don't know.
Okay, but they were still your clients even though you didn't communicate with them, correct?
Yeah, okay.
In the sense of duties of loyalty and confidentiality, I'm sure that's true.
Okay, but not actual work.
If I can go back to something you asked earlier, it looks like my control on the young guy, so I mentioned they contacted me on the 22nd. I said, ultimately, don't file in DC, it'd be a waste of time. The Texas case materialized on the 25th. The case was filed on the 27th. My wife got COVID on the 21st. I think I moved into the hotel on the 24th. This was all sort of happening quickly. It looks like I sent an email to Howard on the 28th that said, you know, this is to confirm that I'll, you know, be retained to help with this case. So it wasn't until 7:11 a.m. on the 28th, and you have this email somewhere.
So that's confirming that you're going to get paid by defending the Republic, correct?
Yeah, and just to confirming that, well, I mean, unfortunately, I'm usually meticulous about doing an engagement letter. But that's it in this case for me, and it's because of the rush and the so that is the engagement letter, such as it is.
Well, the engagement.
Do we see that email? That would be helpful, I think,
Yeah,
to
you have
understand
that
what
one?
his response.
I don't know if I have the email.
Did you turn it over, sir?
I know that there was a representation in one of Mr. Joseph's submissions, but I don't think I've seen the email saying he's going to get paid, but maybe I have. It's just there's.
I sent it to you on February 4th, 2022.
Great.
At
pull it up.
11:56 p.m.
Great.
But whatever, we'll get it to you.
pull it
But I
up.
mean, I could probably get it. I mean, I have to.
It's all right. I just want to ask you a little bit more about that. So you were already representing the plaintiffs when you, I guess, ironed out the payment with Ms. Powell and or defending the Republic.
That's an interesting question. I don't know if I could have walked away at that point. I had, you know, whatever, some number of hours in, but I have walked away from representations
didn't have
even with
that
an
much,
engagement
'cause you don't
letter.
even
Basically
know what
fired the
your meeting
client.
is
I said, you know, I don't want to do this anymore. You can have my work product. I'm out. So I don't know if I could have walked away like that, or even if I could have walked away like that, whether they were my clients.
Wow, this
At
guy
that
is
point, my name had
really
been on
slippery.
a signature block on a complaint, and I hadn't signed it, and that's.
I guess I'm having trouble, Mr. Joseph, understanding your relationship with the plaintiffs. If you weren't their counsel, what were you?
Well, I'd be on the counsel for sure. I mean, when I filed a motion to appeal the BJ, or maybe the December. Look, I don't understand the mechanics. I'm not going to admit anything because in response to a loaded question, because I really honestly don't know at what point I became lawyer for the Arizona plaintiffs. I would say definitely when I did my pro hac vice, maybe on the email on the 28th, and maybe as you're suggesting when the complaint was filed. But I honestly don't know the answer to that, and so I'm not going to give you advice on it because I can't.
I'm not asking for advice. I'm just trying to understand what you're saying. So when when the complaint was filed on December 27th, and you agreed your name and DC bar number and, you know, your office could be listed that stated counsel for plaintiffs, your understanding was you didn't really know if you were representing the plaintiffs?
Yeah, I think that including naming trouble in the signature block like that is sort of like a participation trophy. It's not. If you're not the signer, and if this is a federal court, I don't know if the rules are different in DC, in the local court system. But I don't know. I mean, I simply don't know the answer to that.
Did
you consider Mr. Gohmert your client?
Well, with him, and so I mean, to some extent, the same would be true for him as what I'm saying about the Arizona plaintiffs, but certainly by the pro hac vice motion, it certainly was the intent that I would become counsel as of the December 28th email. But I don't know. I mean, if someone with authority to make such decisions tells me that I was their client when the complaint was filed, I guess I'll accept that. But I don't know it myself. Because I just walked away. I didn't need the court's permission at that point to say, you know what, I'm sick of you. I'm going to back out of this. I think I could have done that, but maybe not. I don't know. I mean, not certainly if I was leaving them in the lurch where they didn't have other counsel. But I honestly don't know.
Right.
She's like, I can't.
Going back to the Arizona plaintiffs, who may or may not have been your clients when you filed the lawsuit.
I didn't file an objection.
Okay, well, you agreed to have your name on it knowing that it was going to be filed, correct?
That's fair.
The fact that you didn't actually, I guess, transmit it electronically to the Eastern District of Texas doesn't mean that you didn't know and approve of its filing.
Well, it's not that you bring up the electronic submission, because that with your name and your signature block is a signature. But just being in the signature block is not a signature. And really signing is we can talk about who was my client or wasn't my client, but the ultimate issue here is going to be signed it or later advocated upon it. And so
I guess that's not responsive to the question I asked. You knew that you knew that the complaint was going to be filed when you agreed to put your name and DC bar number on it.
I thought I started that last digression of mine with a yes, but if I hadn't, I'll finish it now with a yes.
Thank you. And the Arizona plaintiffs, you knew that their case in Arizona that had been filed in the federal court had been dismissed by the federal district
We're
judge.
catching up. We're 6
It
minutes
was on
behind
appeal,
right
yeah,
now.
okay.
Okay, well, let me ask you, so you knew that they have filed an appeal with the Ninth Circuit?
I'm not sure what I knew, quite frankly, about the status of that case and on reflection.
Yeah, I don't know.
I am,
I'm very confused.
I have been involved with other situations where I
Right.
came up with, let's call it a different argument than people had been making in a line of cases. And so I was involved in a new case in an old area, and people had lost before would sort of come out of the woodwork and say, oh, let me join your case. And I have a dismissive way of thinking of such people in my mind as sort of a second chance club. And to some extent, the Arizona plaintiffs were that to me. They were a second chance club. Look, you had your shot, and I mean, I probably knew that they were appealing, but I don't know if I did. I don't know one way or the other. And I saw that as basically irrelevant to the government litigation until I think I was the person that came up with the argument under Heckler versus Matthews, and under that line of reasoning, they argued, even though they were losers.
Oh man, you guys are killing me. Hold on.
I don't know what happened. Oh, it boomed me live. I don't know. It didn't let me. It didn't let me do anything. Okay, that's fine. Well, fuck you. Wow. I can't. I mean, it is at 1 1/4 speed, so I apologize. It's just because usually they speak so very slowly. It's that we have to speed it up in order to save any shred of sanity we have left, which is not very much. Anyways. Welcome to Lolo's Lounge. This is our second session of Wake and Bake. We're kind of, we're already awake, but we're still baking. And this, what we're hearing is rather historic and interesting. And go faster, right? Yeah, exactly. And what is making me be so very naughty by showing this is that these are 3 lawyers who stood in court and lied about fake evidence of potential fraud, and clearly are butthurt about losing whatever they did, and now are whining because they're going to get some kind of discipline. Maybe, I don't know. These panels are kind of whatever, they do whatever. I would argue that they didn't do enough with Jeff Clark. I would argue that they didn't do enough with Rudy Giuliani fast enough. I think they were slow to issue their final disbarment of Rudy Giuliani. That was fucking stupid. And they only suspended Jeffrey Clark. If you remember, he's the one who threatened members of the whatever. What was it? Oh, shit. I can't even remember now. Richard Donahue and those guys, Department of Justice. He's the environmental lawyer for ExxonMobil, by the way. That's who his environmental client was. The ExxonMobil spill. You might remember that. It's a little historical. Anyway, he was one of the ExxonMobil lawyers, and that now he worked. Well, he doesn't work anymore, but he worked in the Department of Justice as an environmental lawyer, and that's the guy that Scott Perry from Pennsylvania pushed onto Trump to say, hey, move this guy into Maine Justice or whatever. He'll do what you need him to do. And he was going to push, he was extorting the leadership, actually, of the DOJ, Richard Donahue and the other guy, I can't remember his name right now, Jeffrey Rosenberg or something. Forgive me for not remembering. But he pressured them and said, listen, either you're out of a job and I'm taking over, or you send this letter for Trump saying that you're launching an investigation into the election. And that was right before January 6th. And of course, Donahue said, fuck you, and the horse he rode in on. And all of the other DOJ leadership actually signed a letter saying, if this goes through and Donahue leaves, we're leaving too. And it was a crisis. and Trump had to fold on that one. So, so anyway, these lawyers know exactly all of the debunking and other things that happened in each of those disbarment cases. If you tell me that this dickwad didn't watch John Eastman's disbarment in California, which was fucking amazing, or even watch Jeffrey Clark's disbarment hearings, which only resulted in a 2-year suspension of his license, and he'll whatever he can do. I don't know. I think he's going to be indicted on something, but I don't know. He's part of the immunity piece where it's official acts. Whatever. We'll see about that. And because he's still out there talking about election integrity and lack of ethics and himself and all that. So Jeffrey Clark, Boxer Boy, I see you. I see you. Oh, this is definitely worse. No, this is definitely worse than Watergate. This is so bad, it's not even funny. And the thing is by design, these schemes, by design, they were meant to be intricate and confusing. But here's the problem, and I will say this until the day I die. I watch MAGA television every fucking day. All right? Every fucking day I watch MAGA television. I don't know why. It's just a weird wonk that I have that I'm struggling to understand how to increase media literacy and what is happening that people are buying such bullshit. You know, and of course we know there's a lot of reasons. There's a lot of, embedded racism and bigotry and other things that is being given even greater voice, right? There's the basically extremist Tea Party on steroids that has taken over, along with new apostolic revelation and, basically Christo-fascists, right? Everybody's figured out how to work together to get what they want in the end and not get in each other's way, right? So these guys have spent all that time, right, in their MAGA rumble world, right? Their echo chamber. You want to talk about an echo chamber? I get accused of that all the time. Bullshit. If echo chambers are facts, fine. I can have my opinion. That's different. And there are people in here with different opinions. That's fine. I have different opinions about things with my friends, with my daughter. So don't tell me I can't handle the heat of a, different opinion. That's just bullshit. That means you don't have any facts. That's what that tells me. So, along with all the psyops and things that have been launched and really have, Q is a psyop, and it's really worked because it's really baked in now, no pun intended, into the MAGA base, right? They immediately hate lefties. We want to kill babies. We want to make their kids gay. We want to, we believe in whatever bigotry has been amplified for them. They're going to hang on to that. So I've given up on convincing people. I'm not here to convince anybody of anything, really. I'm here to learn about how we got here. And in that echo chamber that they have, all of these guys, right? Fucking Sidney Powell, fucking Doug Frank, fucking John Eastman, Jeffrey Clark, Kenneth Chesebro, all of those guys, they believe their own bullshit now after so many years of saying it because they're weak-minded, right? They have no integrity. They don't have a core, really. Their core is so damaged that it can't possibly kind of see any wisdom to reversing course. Hi, Peace Love. So they believe now in their heart of hearts, and you hear it when they sit on the stands of these things. You hear it. They're desperately clinging to storylines and fairy tales that they know have been debunked. I mean, Eastman's hearing was a textbook in debunking bullshit that a lawyer counts on to make decisions. And guess what? He lost his law license, which frankly was his entire existence. His entire existence was built around the gravitas and cha-cha-cha of being a big fucking constitutional lawyer with a juicy position at a private university. So and you know what, Peace Love? I want to be really clear about this. They don't believe it. They believe in the power of the manipulation that those messages enable them to keep control over. That's what they believe in. Deep, deep, deep. They know. Come on. John Eastman is a fucking whatever. PhD, JD, whatever the fuck he is. He knows. This was an ego project for that man. As part of the Claremont Institute and other things other institutes of mass destruction that pumped him up, he wanted to fucking break the Constitution, y'all. That's what he wanted to do. It wasn't about Trump. It wasn't about MAGA. It wasn't about anything. It was about fucking showing the legal community of the world that he was the most powerful lawyer and he broke the Constitution. That's what that fucker wanted to do. Period. Full stop. That's power, and that's what he wanted. So, what I'm saying is that when we are able to see people in a court or in a hearing such as this, they are faced with their own lies and they are faced with facts that they can't, I mean, they can try and squirrel away from. You see the squirreling going on, right? Like, dude's pumping Addy in the bathroom right now, I know. So, they need this needs to happen more often, especially start with the lawyers. And God, I don't know what's going on with Ken Cheesebro, but why he's sitting in Puerto Rico at his house and not in a jail cell is beyond. Anyway, you can tell this is my pet peeve. The big lie, propaganda, lack of media literacy, the frauding of the electorate of this country with lies that has damaged our ability to be human to one another is absolutely fucking at the feet of the people that you see on this screen, except for me and maybe the Kraken. I mean, the Kraken was just a useful tool. I love the Kraken. I can't. Not Sydney's Kraken. Lack of civics. Oh my God. I don't even want to talk about that. When I ran the high school, I was just like, and actually the social studies team did an amazing job of like register to vote kids, and really understanding electoral process, and they would have debates, and it was really good, really well done. But I know that doesn't happen in every school, right? But man, debate is such an important program for kids to develop critical thinking. Please, every school, push for a debate program, please. That's one thing every parent could do that would improve their child's academic performance. How about that? Please join debate. It makes you research your argument. It makes you speak publicly and get command. It makes you react in the moment. It helps with acting. It helps with everything. Like, it's a complete wraparound. Oh, thanks, butterflies. So that's why this is so important, I think, because when these things are on the record, because the point also of what they did wasn't just creating simple lies for people to really grab onto, like, the government controls the weather. Okay, that's easy to say. The government they make it easy. Oh God, perfect debate. And I love that. I love political science. Well, and the thing is that helps, when you develop like critical thinking skills and like research skills. That was another thing we did, was that every senior, before they graduated, part of their graduation requirement was that they would present like a capstone. You know, like this is what I accomplished over my years here or my whatever, my high school years. And this is the resources and these are things I'm proud of. And this is how I researched it. I mean, it was like that was the expectation, is that you would learn how to speak publicly, talk about your work, talk about your methods. You know what I mean? Like just think critically. Media literacy. So anyway, yeah, I feel pretty strongly about this shit. But so again, why these are so very important is that this can be part of the answer. And I don't care if it isn't part of the answer because I really think it is. But let's do it anyway, right? Like the right thing to do for anyone in a position where they have chosen to manipulate the law for their own personal whatever, yayas, that can't be okay for anybody. For anybody. So I hope that we have more of these types of hearings. And frankly, I am pleading. And I guess I know what the downfalls are, but I am pleading with boards of professional responsibility across the country, bars, state bars of lawyers. Please, please, please let us hear these. Please cut these up, right? Please let us hear them. I mean, and we're being a little sneaky today, and it's fine, and I'll take my lumps, but I really hope that it's okay with the universe, because this is information that will disappear into an ether, not the ether, because I'm sure some people have access to transcripts and shit, but we don't. So this is how I'm going to be able to absorb some of this. And it really helps all of us, because then when we're confronted with ridiculous points made by maggots or whomever, at least you have some knowledge in your head that goes, yeah, no, that's not. No, actually, that was this, that, you know? And I think that overwhelming lies with facts is one way, almost like like herd immunity. Yeah, also the difference between feeling and facts. And you know, it's funny from this crowd, obviously, we laugh, the fuck your feelings crowd, which we have that song to write, by the way. I think I have some good lyrics. Let me sing it for you, and then you see what you think. All right, hold on. I'm not going to get it right, but that's fine. Don't worry about it. Just hang with me. All right, feelings. We need cameras in all courts. And I know we've had this conversation, and I understand both sides of it. I don't know what the right answer is, because I also don't want people who are innocent or whatever. Everyone is presumed innocent. I also believe yeah, fuck your feelings is a feeling. Oh yeah, wait. I also believe people deserve a lot more dignity when it comes to going through the legal process. So I don't know. I don't know. I mean, I think there is something to be said for public interest. And that would have to be, I guess, documented in terms of what's the public interest. I think there's significant public interest for this type of hearing, for example. I also understand that everyone is like innocent. So I don't know. I don't know. I don't know the right answer. Feelings. Nothing more than feelings. Feelings but not data. That kills the vibe. Feelings. But hey, fuck your feelings. Oh, is it not live? Oh no, it's live. Here we go. Trying to sow chaos, 'cause feelings I must. I don't know how to do that line. Feelings, maggots have feelings. They simply cannot let those feels. Wait. Feels. They must stop the steal. Data. There's no fucking data that gets through my feelings of fraud. Whoa. That's all I got so far. I gotta change some lines here. Feelings of fraud. I like that better. There's no fucking data. I must stop the steal. Sounds pretty good, huh? I think that one might be a keeper, along with the voter registration and stuck in the midst of a coup. Here I am, stuck in the midst of a coup. That's coming. Don't worry.
Given the pace
It's your
at
October
which we're
surprise.
going. So we were hopeful to end
Thank
at
you.
5 today, if that's permissible.
Well, I'd like to get as much in as we can.
Okay.
We have everybody here. Is 5:30 acceptable?
Yeah.
Let's do that.
Okay. And I don't know if you wanted to deal with the exhibits.
Yeah, let's talk about those. Why don't we start with Mr. Joseph's? This is the one we asked you to submit. Is that something we could put on the screen? Well, you all have copies of, Mr. Joseph says he's distributed versions of this in some electronic format to everyone. Is there, do you know the number of this?
It's 97 and 98. I forget which is which. It's in, I can check my phone.
97 is Pennsylvania and 98 is Georgia.
Thank you.
You're welcome.
What were those again?
Are we going to finally see the
97
Google
is
sheet?
Pennsylvania and 98 is Georgia.
So Joseph 97 exhibits. Do we just call them Joseph, or are they J or
LJX.
OJX?
LJ as Larry Joseph, LJX.
OJX.
097 and LJX 098.
All right.
And
We would like to look at them, but does anybody object?
well, I think we all object that we don't know that they're the truth. I mean, they're not being submitted for the truth. They're being submitted for what I was evaluating.
Right, I understand that. With that caveat, is there any objection to admitting those,
No
I might
objection
need to
from
listen to that
disciplinary
song
council.
again.
Mr. Driscoll?
No, sir.
And
I
I
should
take it
blurt
none
out a
from you,
read
Mr.
music.
Joseph.
Other than what I mentioned,
I'm
no.
back.
All right, they will be admitted.
Orin's back.
Next, we have, what was it, 3 exhibits from Mr. Byrne, which I'm told have been distributed. Which numbers are they again, Mr. Byrne?
900, 901,
could
and
offer lyrics.
902.
Wait, what
That would
happened?
be
BJX, I'm sorry.
BJX. 900, 901, and 902. Are there any objections to any of those?
Not from disciplinary council.
No, sir.
All right, those will be admitted. And last, Mr. Driscoll, you had, I believe, 3 exhibits.
Well, there's actually 4. One of them is already marked previously. It's JHX 146. That would be the upload sheet that was produced by Secretary Hobbs.
What number again was that?
That's JHX 146.
146. And you said is that been admitted or just?
No, it's marked and circulated previously.
All right.
That's right,
Is there an
Orin.
objection to that one?
No.
One of your
Mr.
buds.
Joseph?
No.
All right, to be
You're a
admitted.
blue dot in a red.
And then the
C.
next 3 exhibits were JHX 232, which is the November 5, 2019 certification of
Oh,
the
Jim, let's do karaoke.
Dominion Democracy Suite.
Yeah, there you go,
All right,
Carrie. If they
any
didn't want us
objection
to
to that
show
one?
it, maybe they should
No.
have broadcast it.
No.
No, I'm just kidding.
All right, admitted.
I'm a sore
And then
loser.
the final 2 exhibits are JHX 233 and 234. 233 is the Pro V and V audit report,
Mhm.
and 234 is the LSI compliance audit report.
All right, any objection to either or both of those two exhibits?
No objection.
Very well, those will be admitted
All
as
right,
well.
Teresa, take
Okay.
care, love.
All
I'll be
right.
live for probably
And I
another
just wanted to
hour.
alert, I guess,
hour
the
and a
parties,
half.
and we'll
No, hour and
circulate these
15.
tomorrow. I will circulate them
Looks like.
tomorrow.
Maybe a little
We
later.
wanted, I know that when Miss McGowan from Georgia was testifying, there was a letter to Governor Kemp about an investigation. I think Miss McGowan had indicated that there was a consent order and a report of investigation. We wanted to provide those as additional exhibits. And also, there's been a lot of talk about the Janetsky case. We have a copy of that. I mean, I think you can take judicial notice of it, but we wanted to provide the hearing committee a copy of that as well. But I'll circulate those tomorrow, and if there's no objection,
All right,
or,
we'll take them up on November 6th.
okay, that's fine.
Right.
By which time we have more or less controversy of that. But that's not. All right,
Mr. Chair, I have one request, it'll be a quick one. We've heard, reference to the election lawsuits as quote, efforts to overturn the election. And I would like a ruling from the chair that, that type of inflammatory characterization is, inappropriate at this stage of the hearing. I don't
well,
think that
wishes were
anybody who
horses.
files, a good faith question about an election result or an election procedure is going to want to be tarred as somebody who's an insurrectionist. And so I
calm your
think that language,
tits,
especially
all
in
right?
this
Just calm your
context, is
tits.
inappropriate.
well, I agree with you if we were in front of a jury, but I think the members of the committee
Calm your
can handle
fucking
that.
God,
Yeah.
I can't stand these guys.
Janetsky case.
You break the law, and then it's like, well, okay, well, never mind.
Oh, I've got a copy of it in my house. I mean, I don't know. that-
Okay, it's marked if you want to use
Yep, whatever, yeah.
it.
Although I agree with you, Mr. Byrne, that we ought to limit characterizations to something that
Yeah, tell
that
your
each
boss.
that closely tracks what's in the
Tell your
actual
fucking
complaints.
boss.
You know, if the complaint says we
That's
want
the
you to
Janetsky
overturn the
case.
election, it's fine.
I haven't read
If
it
it
yet.
says we want you to appoint the following electors as representative of the state or whatever,
I want to
that
read
would be
it.
an appropriate way
Not
to
today, but I
characterize
wanna
it,
read
even
it.
though some might say that amounts to overturning the election. We did have the issue before we took a break about whether the amended complaint attached to, what exhibit number was it again, do you recall? It wasn't amended, like, was
Yeah,
the
I'm just gonna
complaint that
say,
was sent
ask
to
John
Mr.
Eastman.
Joseph to review.
Oh,
Please.
yes, the one that
Please.
Mr. Johnson had sent to Mr. Kleinhendler, and then Mr. Kleinhendler had forwarded to Mr. Joseph.
Right, what was it, do you remember the
Man
exhibit
bones
number?
connected
Yes,
to
it was
the
Mr.
ship
Joseph's exhibit
bone.
number 8.
Ship bones connected to the like a backbone. Like a backbone connected to the cotton-headed ninny muggin.
Which exhibit number
It was, I'm sorry, Mr. Joseph's exhibit number 8.
8?
Right.
Okay, so that would be LJX8. The question was whether there is some privilege that attaches to the draft amendment, or draft complaint. I guess it wasn't an amendment, it was a draft complaint for what was originally to be filed in the District of Columbia. Seems to us it's likely that any privilege for that has been waived, but rather than making a decision without adequate information, we'll ask Mr. Byrne, if you want to press this issue, you can file a short motion.
Yeah, why don't you?
Hopefully
slap
500 words or less.
Oh, God.
And while you think this is still privileged, keep in mind, if we're
Oh,
going to apply a
privilege, sorry.
privilege to
I thought it was
that
about being
document, we may
offended.
wind up applying it to other documents that you would want us to look at. If there is a privilege that attaches to those documents, and the disciplinary council may do the same thing. Question, I think, as we see it, is has there been a waiver by however this document was produced to you? And as to Mr. Byrne, who is the appropriate party to assert the privilege, I don't think it's him or Mr. Johnson. It would have to be the actual client, and any basis for them to continue to assert a privilege after the document has apparently already been produced. Last but not least, the attorney work product privilege is not absolute. So it may well be that disciplinary counsel has an argument that they have a sufficient need for this document in this action, that any privilege that can overcome any privilege, if you want to make such an argument.
Ron, spice it up.
All right.
In addition, if I may,
I hope you're not
have
a
an
courtroom
interest
lawyer.
in, I mean, maybe I'm
Jesus.
not allowed to have done it, but
I don't even know
the
anything.
objectionable parts of the complaint were already there before I
completely started thinking
there.
about what I'm going to
That's
eat
what I-
after this stream.
was
during his
trying
talk.
to use it to show. I'd like to be able to show that.
Yeah, would you?
You would like to be able to what?
The exhibit, the legislative exhibit, the allegations about what the legislature did or didn't do in creating the legislative exhibit, those allegations that the disciplinary council finds objectionable predated my involvement.
Oh,
I think
I wasn't even
we're
there.
talking about two different things, aren't we?
I didn't even go to
yeah,
that.
That was not the basis of the objections.
Yeah, so
And
we're all at this beginning.
As I understand what Mr. Joseph's contention is that he said that the draft complaint that he received already had a number of the allegations or most of the allegations that were included in the final complaint that was filed. Is that correct?
That is correct. The important things are the ones that are in the specification of charges.
Right, if you have something to file concerning the matter that I just asked Mr. Byrne and disciplinary counsel to address, you may.
That would know in nature the response or opposition to what Mr. Byrne files.
If that's appropriate.
Yes, right.
I doubt Mr. Driscoll has anything to add to this, but
I don't have anything to add to this, but when you're done, I have one more exhibit to submit.
all right, what is that?
It's JHX 219. This is the Janetzky opinion.
No objection.
No objection.
Apparently that doesn't
Objection.
help you, babes.
All right, that'll be in the JHX 219, you said?
Yes.
All right, that will be in the,
I want the Kraken to be bigger.
Okay.
let's proceed with it.
Sure. And I was going to offer in Mr. Joseph's exhibit number 8. I mean, I don't know if I could just offer at least now the 2 pages of emails, or should we wait until the issue about the attachment? I guess we'll wait until the issue of the attachment is all resolved, but okay, we'll wait, and because I'm going to show him another email, but it doesn't include, I don't think, anything that's subject to the attorney-client privilege or work product. So
Is this the email where he discusses his fee and?
yeah, I was going to show we did find a copy of that, and I will show that to Mr. Joseph. I don't think there's an issue of attorney-client privilege, particularly since the clients aren't on the email.
All right, can we bring that one?
Sure, it's exhibit number, Emily, could you pull up a disciplinary counsel's exhibit number 325 at page 14?
Yeah, we'll have to deal with their shoulders later. I don't know. Well, I could probably deal with them right now. Crop. Where's what? I can't do a crop? Oh, add a filter.
Could we have that blown up, please? My eyes are getting weak.
Really?
Thank you.
It's not the only thing.
And this is the email that you were referring to, or the, I guess, engagement email that you were referring to before, Mr. Joseph?
Yes.
Okay, and in the District of Columbia, the lawyer's required to provide a written statement to the client about the basis and rate of their fee. Am I correct that this was never shared with any of the plaintiffs in the Gohmert case?
I discussed it with Louis Gohmert. I didn't have any contact with the Arizona people.
Okay. And you were being paid by Defending the Republic.
That's right.
Okay, and that was Miss Powell's, I guess, organization.
Yes.
Right.
I'm gonna make her head bigger.
All right.
Bitch. What?
Go ahead.
All right, you can take that down, Emily. Thank you. Before the break, Mr. Joseph, I was asking you about the Arizona plaintiffs and the issue of their standing. Did you, and I can't remember if I asked you this or not, but did you read the district court's decision in Arizona about their standing or lack of standing?
That's not
I
great.
don't recall. I was aware of it, I think.
Emily, if you could pull up disciplinary counsel's exhibit number 263. And if I can, this is the order of the judge dismissing the case dated December 9th, 2020. And if I could have you go to page 7, Emily. And if you could zoom in on the last full paragraph. Or I guess both paragraphs on page 7. Starting with plaintiffs argue.
What? Wait, what? Plaintiffs argue that plaintiff electors should be considered candidates, and thus they have standing under the Electors and Elections Clause pursuant to a blah, blah, blah. That case, based on the operation blah, blah, blah. Plaintiff electors likewise assert that under Arizona law, they should also be considered candidates. However, the electors are not candidates for office as the term is generally understood.
What's the point?
Well, my question is were you familiar with this ruling at or around the time that the Gohmert case was filed?
I honestly don't recall. I don't think this
you have
undercuts what I've been trying to say at all.
And you didn't think it was relevant to whether or not the Arizona plaintiffs had standing in the Gohmert case?
It's just that I was asserting standing under Heckler versus Matthews, nothing to do with it.
What?
You were also aware that in the Bowyer versus Ducey case, the case filed by the Arizona plaintiffs.
I'm sorry, I thought that's what this was. It's not.
It is.
No.
Okay.
Oh,
okay.
It is.
You were also aware that the plaintiffs, your clients, or the plaintiffs, made allegations about massive election fraud.
Mm. Were you aware of that?
I really stayed away from the Arizona stuff because again, my of them was what I was characterizing as a second chance club.
I like a wet
Like
heat.
they were sort of irrelevant.
I like my heat
And then
moist.
the Heckler versus Matthews
You know what I'm
thing
saying?
came later, and we included that. And to my knowledge, that's the only argument that we put forward that was relevant to them.
Yeah. Right.
Well, let me have you
What
go,
else?
and I'm going to come back to the court's decision
Big
in
nothing
the
burger.
Bowyer case. 270, Emily, if you could pull up 276. And I'll have you go to page 2.
Okay. What am I reading? Blow it up.
Throughout the complaint in Gohmert, there were allegations of massive multi-state electoral fraud
Oh, yeah, there's no way.
and
to read
electoral fraud in the various states. Do you recall those allegations in the
I
Gohmert case?
guess there was only one, but if you said it or throughout, I'd have to
Oh, yeah.
confirm that, I guess.
know.
I believe that the word massive was used more the word fraud at least once.
that. Yeah. Right.
And you were aware then that these claims of fraud were also made in the Arizona federal court action.
I don't know what they argued there, really. I mean, I
Was I
didn't
even there? Was that
familiarize
even real?
myself with that.
What
Your
is the Seventh
standing is,
Circuit or
again, as
whatever it is
a
you said?
someone was as a citizen rather than being involved as a lawyer, was that they generally stayed away from fraud because it couldn't be pled with particularity.
Well, in fact, findings, you didn't think the ruling of the federal judge in Arizona was important before alleging massive fraud in the Gohmert case?
Okay, so I think it's the max. Massive fraud was 1,000 votes or 1,000 ballots.
Yeah.
And
Nothing
I
burger.
mean, really what that, I mean, maybe it's hyperbole, maybe it's not, but the key thing is outcome determinative. So in a really close, like,
What?
excuse me, really close race, maybe a few hundred votes is massive. And go out, maybe 1 million votes is not massive. And
Sir,
I think what government alleged was, the gist of it was, frankly, not even that we, the plaintiffs, are saying this, but members of Congress are saying they're going to challenge these things, and they're entitled
he got
without
swept
Rule
up in the
9B from
enthusiasm
the
of
Federal Rules of
Congress.
Civil Procedure, without
And
Article
he
3
said,
limiting
some
what they
people
can
think
and can't
that's massive
consider.
fraud.
They're
Some
allowed to
people
say,
don't think
this
that's
doesn't
massive
work.
fraud.
And so then, the massive fraud, if fraud is a word that has more than one meaning, and you're taking it to mean ballot stuffing and skullduggery of the
I'm trying to translate.
Well, you're taking it to mean actual fraud is what you're taking it to mean. And
Uh-huh.
in Texas and in most states, I think.
Let me do this.
There's two.
What he's saying, I'll stop him for a minute. I'm sorry. The sound is the sound. There's nothing I can do about it. I really apologize. What he's saying is that in this Gohmert case that he has his signature on, that he was a lawyer on, or he used information from it, he's saying that although this case, the Texas or Gohmert something that became the Ken Paxton case, he's saying that because Gohmert's basically asserting a bunch of massive fraud, right? Or maybe it's vice versa. Maybe the Texas case became the Gohmert case. I don't know. One of them, yeah. We'll get those details. Jesus Christ. So she's saying, listen, you signed on to this saying there was massive amounts of fraud. What are you, where are you citing, blah, blah, blah. And he's basically saying, as I can understand it, that he doesn't know what this document really says. And he says maybe some people think 1,000 votes or 1,000 ballots is massive fraud. So he's pulling numbers out of his ass, or out of Louis Gohmert's ass. And he's basically trying to skate so fucking hard away from this. It's not even funny. So I'm so sorry it's so hard to hear, but I'll slow him down. How about that? That might actually help a little. Oh no. Oh my God. He's on normal. Oh shit. It's not even on speed. Okay, here we go.
At least two kinds of fraud. There's actual fraud and constructive fraud. And it is defined differently in places. So I think Michigan's got a rather narrow view of it. Whereas Texas, I believe, would have a view of constructive fraud that would include fiduciary duties, violating the public right or public interest. And I would argue that's what Elias is in the business of doing. And I'm using him as a metaphor for the kind of election challenges that take the legislature's election laws, which are supposed to be what governs our elections as a matter of federal law, and they try and bring them to their advantage. And I would like to see that stop. And I would argue is fraud.
Yeah, go ahead.
Basically, he's saying, I just wanted them to stop and look at the fraud. That's what he said.
Is it your contention or your belief that when a congressperson attempts to avail themselves of the federal courts and district courts, they're not bound by 9B?
Oh, absolutely, they're bound by 9B. When you're sitting in the 12th Amendment and doing their work there, they swear to uphold the Constitution. Oh, you're telling me to stop, I'll stop. No.
I'm swayed, but yeah.
Okay.
But I
answer the question, and I'm sorry for not being clear, but yeah.
So, Emily, if you could go to page 9 of the complaint in the Gohmert case.
God, this guy is a nightmare. Fuck. Jesus.
And I'm looking at paragraph 24, Mr. Joseph. You can blow that up, Emily, so Mr. Joseph can read it. Okay. So there's the use of fraud and illegal conduct. What did you mean? What were you telling the court when you said that there's substantial evidence of election fraud and other illegal conduct?
I would have to do a red line strikeout compare to what existed before my involvement. My contention is that if you don't sign a document and you don't later advocate on it, and you're the person that put it there, that you disciplined for it. And that's a matter of religion, and it applies to the district of Columbia, just like it applies to the state of Texas. And so I didn't. So I have to look. I mean, if I added, for all I know, I'm not saying I did or didn't. The other illegal conduct, that sounds like it might be some sort of wink at what I actually care about. But most of this paragraph deals with my involvement. I didn't sign it. I didn't advocate upon it.
Okay, this is the Gohmert thing. He says he didn't sign. Okay. So I'm just going to read it. The Arizona electors, along with Republican presidential electors in Georgia, Michigan, Pennsylvania, and Wisconsin, took this step as a result of extraordinary events and substantial evidence of election fraud and other illegal conduct before, during, and after the 2020 general election in these states. The Arizona legislature has conducted legislative hearings into these voting fraud allegations. That's the Rudy hearings. We watched those about 6 months ago. The Arizona legislature has conducted blah, 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 and is actively investigating these matters, including issuing subpoenas of Maricopa County, Arizona, for which accounts for over 60% of Arizona's population and voters, voting machines for forensic audits, which they ended up doing. And guess what? What did the audit turn over, kids, in Arizona? Do we all remember? Come on, say it with me. Biden got more votes. That's it. Yes, exactly. Carrie, that is a perfect representation of what this guy is saying, along with anything else he can say in order to try and save his ass. This is ass saving 101. Not really good. Probably mediocre. Although, who knows? Maybe it'll work. Who knows? I don't know.
I didn't put it there. What they meant, I don't know. We'd have to ask them.
Well, you're plaintiff's counsel in the case, so I'm asking you, what did you mean by it?
I wasn't to sign this document. I don't think I would have signed it, for the record. I think it's unprofessional to attach exhibits to a complaint. A complaint is meant to be short and plain. And if you have an exhibit, refer to it in the text, and that's it. You don't need to attach it. So I don't, it may be that you can pin this document on me, but I believe that's wrong, and it was certainly not my belief. And if I'd have known that you had the capacity to do that, I wouldn't have had my name on it, or I would have insisted that it changed. But under the rules, as I understand them, I didn't have to say anything, and I didn't. I was new to this party, and I didn't want to say this is rubbish.
What?
That seemed rude. I didn't want to do that.
What?
I didn't think I had to.
He said, I didn't think I had to say this is rubbish. I was new to the party. Oh my God. Ladies and gentlemen, he, she's, and theys, please fire this man if he's your attorney. Thank you.
If you end up thinking that I had to, then I'll obviously regret it.
So you didn't think you had a choice but to put your name on the complaint?
I didn't say that.
Okay.
I said, putting my name on, sorry, put my name on the complaint without signing it, without being the person that put it there, without later advocating on it. I have now absolved myself from it by not being one of those, I think it was 4 things.
Oh.
That's my view of the law. And my view is that law.
I didn't write it, I didn't sign it, I didn't endorse it, I didn't advocate for it, so I didn't do it.
So, otherwise, so I get to prevent you.
But sir,
What's rule 83B?
That says that these rules are preemptive and no one can be, I'd have to pull it up, it's in my exhibits, but let me put them up front.
I think it's the rules are talking about.
The federal rules of civil procedure, which are federal law. And you said, who's,
I just want to know what
Right.
Which body?
FRC 283B.
So let me ask you,
Whatever that is.
about your responsibility for your name on a pleading. You did consent to have your name on this pleading,
Oh, so his name was on it.
and you consented to have your name on the other pleadings that were filed subsequently before the district court
Yes.
and with the Fifth Circuit?
Yes.
And,
That one.
pardon?
I think I saw that one.
Okay, so you're totally responsible for every word in that, correct?
Sorry.
Sure.
Oh, great.
Just,
That, yeah.
okay. And is there a difference in your mind
Mhm.
with the pleadings where you consented to be named as plaintiff's counsel
Mhm.
before and after you were admitted pro hoc vice?
I don't know what that means.
Yes.
Okay, so once you're admitted pro hoc vice,
Pro hoc v.
you're responsible for everything in a pleading.
Oh,
No.
oh,
You would have, and, the duty, if something was material,
oh.
to a duty to correct. And duty to correct, I don't think applied until you were admitted for hoc vice. And and more importantly, under, you, I think we, I don't know if I can say DC, call it Rule 3.1, I think they call it 3.01 or something. But the sort of dishonesty in the 3 series rather than in the 8 series,
Okay.
you wouldn't be responsible for that because it created your involvement.
Okay.
Whereas the duty, again, there was no duty to correct something that you weren't responsible for. But if there might be an ongoing duty to correct something material under Rule 3.03 in Texas 3.3 here.
Uh-huh.
But nothing predated your involvement because you were involved from the very beginning. This lawsuit was filed.
What are we doing?
Okay, so
Are we consulting?
I'm sure the royal we will get to this in the Michigan case, but that's a really good example where the Sixth Circuit parsed this.
Oh.
What's that guy's name? Lynn Wood was,
Oh.
Lynn Wood tried to argue this, but he was involved held to be involved, whether it's true or not, I don't know. But he was held to be involved in sort of setting this all up. And so he was like an instigator. And so the fact that he was only listed in the signature block, it didn't do anything, didn't get him off the hook. Emily Newman, by contrast, was listed just like Julian Howard and Brendan.
Oh, yeah, we had that. We had that in what.
But she got off because she said she didn't do anything.
I don't want to talk about P. Diddy and I don't care about I mean, I care.
You'll have to decide what to make of what
Lynn Wood.
the Sixth Circuit did with Brandon and Julie, because I think they didn't raise that argument until their petition for rehearing en banc, and that might have been too late. But it might not be res judicata anyway in one of these proceedings. But you'll have to decide that. But I'm like Emily. I'm not a Lynn Wood. I didn't put it there. I didn't instigate it.
And Donald Trump.
Sorry, I'm not.
Do you want some water?
I have some. Thank you.
Okay.
Thank you.
Are you dying? Are you upset? Are you going to cry?
So let me think.
Cry? Oh, I'm going to shut up.
I mean, the best example of this is the Wachovia case. Before Judge Parker's decision, that was really it on this issue. And there, class counsel appointed by the court was held responsible because his name was in a pleading, that is a complaint, even though he didn't sign it, because he was in charge of the litigation. By the same token, he was held not responsible for misrepresentations in a summary judgment brief, even though he's court-appointed class counsel and his name's in the signature block, but he showed that he delegated it to other people. And so he wasn't responsible for that. And that's the bright line between Emily Newman, and I think I fit that same situation, as I believe do Brandon in the Michigan case, do Brandon and Julie. It's just they didn't raise it until too late. So you have to decide a res judicata issue. Is that fine? Is that oopsie of not raising it soon enough binding on them, even though they too, like Emily, didn't do anything? That's I don't know how that resolves. on the
You are
preclusion
fucked,
issues,
my
but
friend.
I'm like Emily. I raised it timely. It's like, I didn't do that. I didn't put that there.
What?
I'm sorry, carry on.
Yeah, I'm trying to understand.
Yeah.
So it's your contention that if you weren't the instigator, you weren't the one who initially prepared and circulated a complaint, you're not responsible even though you joined in.
Well, I mean, okay, so there's sign. I mean, you have to look at Rule 11.
No, I'm just asking you what your understanding is in the Gomer case.
You didn't put it there. You didn't sign it. And you didn't later advocate upon it. That covered, those are the bases for being responsible.
Okay, so under your theory, with Mr. Johnson, who initially circulated the complaint, he was responsible.
I don't know.
Objection,
Well, I don't wanna
objection,
do-
counsel characterized something
fuck
as
my
initially
client.
circulating a complaint. None of that evidence is in the record.
Don't
There's
fuck
one
my
email
client.
that has his name circulating something. So I object to the question.
Yeah, that's probably a good idea.
And I don't have the foundation, because I don't know who put it there. Yeah, he could have the same argument I have. He probably does, but I don't, I certainly don't know who put it. Someone wrote those words.
I don't get this.
And that person, is it like the Lynn Wood example?
Really?
They
That's what it's
put
like?
it there,
You're comparing yourself.
but I
to
don't think I am.
Okay. Sure, honey.
When my behavior would have been, I mean, again, so one of the things that A3B says is notice is required. And you have a novel theory here. I think you're wrong as a matter of federal preemption, but
Time for
disbarring someone, I mean, I look at people's attention. That's like my Band-Aid theory. It's your version of my Band-Aid theory. We'll disbar a bunch of people and then no one will ever do that again. Rule A3B says you got to provide notice before you discipline someone on something, for these rules. Anyway, carry on.
Thank you.
Carry on. Yeah, thanks. I will.
Getting to the allegations in the Gomer case, you, I guess, quote extensively from the joint resolution that was attached.
I don't. I mean, it was in the complaint. I guess I don't remember what's in the complaint, but yeah, that resolution, that language predated my involvement. It was in there. I didn't think it was material, and so I don't think there's any duty to correct it later. But I didn't put it there. I didn't sign it. So it's for its presence in the complaint. I don't think I'm responsible.
I'm not. Why am I here?
And that joint resolution, I'll call it a joint resolution because that's, I think, the label that was affixed to it. That was the only exhibit attached to the complaint that was filed in Gomer, correct?
I believe that's correct.
Okay. And Mr. Johnson was the one who provided you a copy of that?
Yes, that's another email in my, I think it's the one that follows the one you.
Okay, Emily, if you could pull up just Mr. Joseph's exhibit number 9.
Yes, please, Emily. Thank you. Pull that bitch up. Let's see it. Let's see what the man was sending. What was he sexting? And to whom? Here we go.
And this was an email, Mr. Joseph, that you received from Brandon Johnson, December 22nd,
Yes.
2020. And if you could go, there's actually 2 attachments according to the email. One was the joint resolution, and the other was a Navarro report, the Immaculate Deception. Were those the 2 attachments? Okay. And Emily, I think you're now on the 2nd exhibit. I want you to go back to the 1st. The version of the joint resolution that Mr. Joseph provided is only 4 pages, correct?
I believe you meant to say Mr. Johnson.
Sorry, yes, you're absolutely correct. The joint resolution that Mr. Johnson provided you on December 22nd had only 4 pages.
That's correct.
It left off the 5th page that Mr. Bowers was showed yesterday that included the concurring or the members elect.
I believe there's a member at least elect on the
Gotta get them all in.
pages that I was provided.
Okay, Emily, if you could scroll down and if you could identify those, Mr. Joseph.
None there. There's one. Senator-elect, Nancy Barto. Any more? Nope, that's the only one.
Okay, and if you could compare that, Emily, actually, if you could pull up disciplinary council exhibit number 274, which is the version that was showed to Mr. Bowers yesterday, and go to the 5th page. And you can see members elect concurring.
Fasten your seatbelts. It's going to be a bumpy.
Yeah, interesting.
And when Mr. Johnson provided you the first 4 pages of this document, were you aware that there was a 5th page?
No.
Okay, and it was only the 4-page version that was attached as a single exhibit to the complaint in Gomer, correct?
That sounds correct.
And let's go to the actual complaint, and then we can use that then. And identify that. Emily, if you could go to disciplinary council's exhibit number 276. And if you go to page 29.
That song.
And it was only the first 4 pages without the concurring members that was submitted to the court in Texas.
Except for the one member-elect that was listed on page 4.
Too many dicks.
That's actually very important to me because when I saw that, my eyes rolled and said, oh, this is ridiculous.
Oh, really?
So if you thought it was ridiculous, why did you agree to have your name and bar number on a complaint that quoted extensively from this and attached this as the only exhibit?
Yeah.
Because I didn't think I was signing it and staking anything on it.
Oh, so
based on the rules that I mentioned.
Really?
So you knew this was a ridiculous and fake document.
He did not read the document that he attached himself
He
to.
testified that it was ridiculous,
Pro
not
Hacha Vitae.
fake.
Okay, let me ask you, you knew it was a fake document?
I don't know what fake means. It's,
You're a fake
it's,
document.
I mean, I had a colleague once that used an expression that has stuck with me. It's standing close to the lantern and waving your arms. It's a sophomoric, it's trying to sound important, but it's, I don't know if it's fake. It's more sophomoric than fake.
What is happening?
Did you raise these concerns with your team of lawyers?
Like I said, I was near the party that seemed rude and I didn't feel that I needed to because I wasn't being asked to sign it. I wouldn't have signed it.
Oh, but your name was on it.
I wouldn't have attached this exhibit. In fact, in the Fifth Circuit, the thing that I did sign, there's a rule that says you have to, the emergency rule, says you have to attach everything relevant. I didn't attach this.
Really?
You were involved in the Supreme Court petition though, correct?
Yeah.
Okay, and you reviewed that and you approved that?
You attached the complaint because
I didn't really.
There's a value of doing that. I mean, they don't have a rule that says omit stuff that's not relevant. I mean, so you know, whatever. I wasn't the decision maker. I don't think on that. And so that it was included.
Hey, Badger, babe, how are you?
Doesn't need to be in my view, but you know, I don't think there's any harm in it.
Right.
It's not advocating upon it. I mean, the idea that this document in an exhibit in an appellate filing would
I don't even know that woman.
Raise an argument that wasn't raised in the body of the brief is absurd because if you say that including it in the appendix raises the argument somehow, the fact that you don't raise the argument in the brief means you've waived it. So you're saying that we simultaneously raised and waived it. I mean, that's nonsensical. It was included that no one was going to be fooled by this document. It's self-disqualifying.
That's right. The no blood, no foul defense.
And judge would which includes the Supreme Court, would recognize that I wouldn't be misled by this at all.
That's redunculate. What? Wait, what? Oh, they weren't misled by that at all.
Okay,
Oh,
but
so
you
it was a
did
test?
quote
Were
from
you
it
testing them?
in the actual complaint.
So many questions.
And you referred to it in the actual complaint.
Yeah.
It wasn't just slapping it on with ever.
That wasn't
Exactly,
me.
bitch.
It
wasn't me. I was over on the sofa.
This is strange,
I
quite
was
frankly. I mean, I
sitting
think
on the
it's just
counter.
irrelevant and would leave it at that. And I
This
don't
is
think
totally
I had an obligation
irrelevant.
to raise
I don't
that.
know why you're asking
But
me.
if you want a possible justification for it, there
Didn't
is
sign the
the
document.
requirement under, this is the
Don't even know that
Electoral
girl.
Count Act as it existed in 2020. I think it was amended in
What a
21 or
weak
22,
man.
I forget
What a
when.
weak
But
man.
under section, under Title III, USC Section 7,
Weak bitch.
the electors, in order to be counted, had to meet on
Yeah, what day was
whatever
it?
day it is, the
What is
fourth
it?
Wednesday
The
after the
ascertainment
third
date?
Tuesday
Uh-huh.
in
What?
December, or
December
whatever that
14th?
language is
Yeah.
in the
Yeah, we get it.
relevant statute.
Uh-huh.
And under the terms set by the legislature. And I
Right.
think Mr. Bowers said yesterday that required meeting at the meeting at the Capitol
Right. Oh, you're funny.
with the
You better be crying.
with the Secretary of
inside
State or
this
witness
thing.
or something. So there's a requirement, a box checking exercise
Right.
that they show up. Now, as a practical matter, if we had succeeded in having the Electoral Count Act declared unconstitutional because of the serious bicameralism, presentment, those sorts of problems.
Okay.
The fact that they did or didn't meet on that Wednesday would under 3 USC 7 probably wouldn't matter, but it's relevant to the pleading. I mean, it has a relevance to the document, separate and apart. I mean, you're basically focusing on the standing close to the lantern and waving your arms, trying to sound important element of it, but it does check the boxes that we met on this day.
Hey, we
We
did
this.
Yeah.
I mean, says that are authorized,
Shits
but I
and
guess, I mean,
giggles.
that's just obviously not true.
It's absurd.
Okay, I think we're talking about two different things right now. You're talking about the certificate that was filed with the archives by the Republicans, your clients in the Gohmert case.
I wasn't aware of that, and I'm still not.
Oh
But
my
no, I
God.
was talking, maybe
You're
I
the
was
worst
misspeaking.
lawyer.
I thought that the
Take his license because
the
he's
complaint
really just
and
a
the
bad lawyer.
resolution talked about meeting on
Cash
that.
Patel to
It was
be
December 14th, I think.
That
disbarred.
was the
Why
actual
is he disbarred?
certificate
Wait
that
a
was
minute.
filed with the archives.
I'm wrong, then.
Wait a fucking
I'm
minute.
withdrawn if I could.
Okay, because I think there was a point made yesterday that
Wait, what?
Vice President Pence wouldn't have looked at anything other than what was filed with the archives, correct?
I know that, and that I found very interesting because I don't know
Mm.
if the archives have the ability to screen,
Hmm.
like,
Right.
um,
Are they
obviously
open the
bogus
envelope?
document. So if someone sent, I'm the 500 electoral votes from Atlantis
Right.
or from the moon,
Yeah.
would
that
the
go?
archivist have to send that to
Would that?
to
I don't
Congress?
know.
I don't know the answer to
I don't know
that.
the
And
answer.
this
I
is,
just filed
where they
suits
fit
against it.
between the
Whatever it
moon
is.
and just the rival slate of
Right.
electors in
Just a rival
a
slate.
particular swing state.
Right.
I think,
Okay.
they're not as crazy as the moon. We
Really?
can argue about how crazy they are or aren't.
Well, we will.
Maybe
be.
and another
Funny
thing
you
is
say
that they have to check that box because
It's-
if the litigation, which
It's
was
funny you say that, sir, because they're about to. Because if you aren't familiar, sir, there's a number of indictments and unindicted co-conspirators that will be going through some things in Arizona. So, sir, I have good news and bad news. Good news is you're going to get to some of the bottom of all those burning questions you have or didn't have when you were or were not signing said documents and submitting them to the Supreme Court. But I will be telling you, yeah, they never got there. I think did Mike Pence's guy somebody intercepted them, or the archive just filed them or something. Went, yeah, okay, whatever. I don't really recall, but I don't think they didn't use them and didn't send them on to the vice president. Or I don't know. I should stop talking until I find out exactly what happened with the fake certificates because something happened. Ron Johnson knows a little bit about. Anyway, okay, sorry.
Was still pending had succeeded, then they could have had a Hawaii situation where they were swapped
right away
as late as
Oh,
January
thank you.
6th. So, I mean, it's relevant to the complaint. I understood why. I mean, I don't know why it was there. I think it was a little bit of the sophomore standing close to the lantern,
Right.
waving your arms. But it did have a relevance in the sense that it established some small element of their bona fides if they ever
Really?
got to the point where they were
Fake
declared the
bona
winner.
fides?
If that, because that was still possible.
Aren't those fake bona fides? No,
Well,
it wasn't.
let me
No, it wasn't.
follow up
possible.
on that, and then I'm going to get back to the joint resolution. You said your clients, the Arizona plaintiffs, had to check that box. That meaning they had to file this certificate with the archives, correct?
I guess that's true. I was really referring to the box of showing up and having a pretend ceremony. I mean, there's the actual ceremony and the pretend ceremony. And the pretend ceremony, you have to do it because if you're later declared the winner, but you weren't there on the Capitol on the December 14th in this year,
Had you not
then
bets
they could say you didn't comply with 3 USC 7. So I assume, I actually guess I in truth don't know, that the Hawaii electors in
Oh no.
I guess it would have been in late 1960 that they went.
No. Okay, let's talk about that. Because for those of you who aren't familiar with this bullshit, that's another favorite. Well, but what about Kennedy and Nixon in 1960? Well, what was happening at the time that both sets of electors submitted their votes for their candidate was that Nixon was winning, but it was such a close race that they did a recount, and the recount was still underway at the time that they were supposed to send the certificate of ascertainment of their electoral votes to, the archives or whoever, the vice president. So they did, but it was very well known. It was talked about. It was public knowledge. It was an official recount was happening, not just some bullshit Rudy Giuliani, Sidney Powell Kraken case. It was a legitimate state recount. And it turned out that while Nixon was leading in the first count, after the recount, they verified that actually it was Jack Kennedy by like 150 votes. So that's why they did both slates of electors. It has nothing to do with 2020. Zero, nil, zilch, nada, 9. Anyway, sorry. Just want to make that clear for people who may not know, although I know all of you know, and I'm sorry.
Through some exercise, and then they were, come January of 61, they were redeemed or proven right, or whatever the right word is. But I don't know the extent to which they went they jumped through the hoops prematurely in case they might, in case that prematurity might later mature.
Yeah, different, totally different.
So you say a pretend meeting, so you would concede or admit that your clients, the Arizona plaintiffs, had no authority or statutory right to hold themselves out as electors.
Well, it wasn't over then.
It wasn't over.
What wasn't over?
Well, the case was still in the Supreme Court.
It was over.
Something could have happened.
No,
What
it was
case?
The Ducey case that you've been referring to, I believe, was still in the Supreme Court at that point. Could have happened. The Supreme Court might have said, you know what? This elections clause stuff has to stop.
Not your job.
We're going to
Not
pull
your
the Band-Aid
job.
off. Could have happened.
You don't anticipate what the fucking Supreme
having
Court
taken
wants.
the precautionary step,
It's not a precaution.
while it was still
It was
premature,
deliberate.
but with the possibility
Guess
that
what?
it could
John
later
Eastman,
mature,
that guy down there, the
you know,
sack
that
of
might
shit
be,
looking guy, like the bag of
might have been a
mayonnaise
good strategy. But
that I got down below me.
did they ever become actual
Where he
electors?
belongs?
No.
And so if they were to have
Ask that guy.
represented in a certificate filed
He
with
laid
the
out that they were gonna
archives
do
that they
it
were
in order
duly
to
elected
cause
and
a constitutional
qualified,
crisis.
that would have been a false
Fun
statement.
fact.
That would have been a misrepresentation.
I think you're asking me for a legal opinion, and I
Oh,
don't
I'm
think
not a lawyer. Wait,
it's
I am.
appropriate for
Shit.
me to I don't know what their legal
I don't know.
situation is right now.
I don't know what
And I
electors
don't
are.
think
What's
I should add to it. I don't see how what I think is relevant.
Well, did you believe
is
that they were
relevant?
duly elected? These were the competing slate of electors that you were representing in Gomer.
Exactly.
Did I
bitch.
believe that they were duly elected? No.
Okay, and were they duly qualified?
Did I believe, I'm going to change your question if I may slightly. Did I believe they were
No.
duly qualified? As I said, it remained possible that they could become so, and that there
No,
might be
honey,
an
it
advantage
didn't.
to checking the box of meeting and doing the
When did they come
ECA,
out with that
Electoral Count
slogan?
Act.
God damn it! Now I got to put my joint up and check.
Conditions precedent. And that might be the sort of political theater, the way this works,
Baby,
using the
it ain't
Y
political
example.
theater. It's
But
treason.
in the end, obviously, no.
Jesus, I hate these guys. Okay, wait. I need to know.
And
when
you knew that there was nothing qualified about the certificates that your clients had filed with the archives.
I didn't know that they'd found anything but the archives, I guess. I mean, really,
But the joint resolution you did know about,
yes.
and that was appended to the complaint.
It was.
And you knew
December
that the
11th.
Arizona legislature was not even in session.
December 11th.
I did not know that. And I
It
think
was
we learned from
before.
Mr. Bowers yesterday that they could have shown up in.
Fox.
It's embarrassing. It's the capital of Phoenix. I think it is. But
Yes.
yeah, I mean, they could have shown up in Phoenix and said, hey, we're all here. Let's hold a session.
Ladies,
I didn't know
these
that
are
that did or
lawyers,
didn't
fucking
happen.
run.
And there were, I mean, just so we're clear, I am, what I did know about the Arizona legislature at that time was that there was this dispute going on between Maricopa and the Senate. So the Senate was doing things. I don't know if they, what was that expression, some Latin thing, sin 9 or something.
Right.
Whatever, the meeting we're out of session
Wow, you're the
that
shittiest
Mr. Bowers
lawyer I've ever
mentioned.
met.
I mean, I didn't know, I mean, I quite frankly didn't know whether they were in or not in session. And I really don't think it's material.
11th. December.
So I guess I'm just wondering a little bit about the due diligence. So you didn't think
Anybody.
whether or not the legislature actually approved this joint resolution was relevant or material to the representations that you were making to the court in Gomer?
I didn't make any representations to the court in Gomer about that. I didn't sign the complaint. I didn't put it there. I didn't later advocate on it. And
I didn't even poop in their bathroom.
it says, I mean, which is probably literally true, and this goes to the sophomoric nature, but it says members of the legislature passed a resolution. It doesn't say that the legislature passed a resolution. It's a difference. I mean, again, it's
okay.
let me back up there, because this is just not material. So Rule 3.1 in Texas says don't do anything deceitful. Rule 3.3, the duty of candor, or 3.03 in Texas,
He's getting mad.
the duty of candor to a court
like,
includes
"This is
going
all
back and
relevant."
correcting something that's material that was previously said. If they had never done this little stunt with the showing up at the Capitol to cast their so-called electoral votes, they had never done that. They could still have done the Heckler versus Matthews argument that I'm making. It just wasn't material. I know you think it was. It wasn't. Or I didn't think it was.
So why was it in
And
your
I guess I'll have
suit?
that argument with Mr. Sanderson.
Or somebody's
But we'll
suit?
see.
That your name
But
was
you
on.
will agree there was a number of allegations about massive election fraud and fraud in the Gomer complaint, to which your name, with your permission, was included.
And I believe it was used once, but you've told me it's more than once. I'd have to confirm that. And it doesn't surprise me that the word fraud might have appeared more than once. Fraud can include constructive fraud in Texas. And indeed, I should add that in the Fifth Circuit, Rule 9 doesn't apply or didn't to constructive fraud. So that would actually make sense that that's what they're referring to. Because if they were actually talking about massive fraud of the actual fraud variety, ballot stuffing, electoral shenanigans, not electronic shenanigans and the like, they would have had to do that with particularity. But if they were just saying there was massive fraud, and that includes Mark Elias and people that did similar things, then that would, in other words, breach public duties. That would make sense, and that did happen massively in the 2020 election.
Oh, that's not fraud, babe.
Okay, well, let me have Emily, if you could pull up 276 at page 10.
Come on, DC, don't fucking let me down. They probably will. What are we doing? Oh.
And I want you to focus, Mr. Joseph, on paragraphs 26 and 27.
Public reports have also highlighted widespread election fraud in other contested states that prompted competing electors' slates. Republican senators they think that they get away with it on the war room, so they think.
Let me start with paragraph 26, which is
it's easier.
Yeah, it's shorter.
Members of the House of Representatives
am I correct that this widespread election fraud that was alleged in the complaint, which you permitted your name to be added to, was not constructive fraud, but actual fraud that was being alleged?
I think both were alleged. There were widespread public reports of the kind of elections and elections clause and electors clause violations that I've been talking about. It's a very vague document that I imagine that language was there before my involvement.
Really?
I read to a red line strikeout compare of
oh my God, you really don't do your
the
job.
complaint as it reached me and the complaint was filed. And
what do you do?
Maybe anyway, I will do that, and we'll talk about that later. But
no, we won't. I think
so. To your point, I don't concede that this postdated my involvement, and B, that statement is entirely consistent with both types of fraud.
I'll read it.
And the public reports, if you go down to the footnote, Emily, please.
Oh, see, in the copy,
actually the second one, because the footnote is, I think, footnote 12.
To the secretaries of state,
the only public report you cite is the Immaculate Deception, 6 Key Dimensions of Election Irregularities, the Navarro report that you got from the Bannon's war room.
Held subject to the order of the President of the United States and
Again,
the Senate, the Vice
wasn't
President.
me that did it, but I haven't looked at that report recently, and I don't know what it includes.
Well, isn't that one of the documents that Mr. Johnson sent you on December 22nd?
Yes.
Okay, and that was one of the, I think he referred to it as the district court complaint attachments.
In the email, yes.
Okay, and you didn't end up actually
Thanks for
attaching the Immaculate Deception, but you did cite to it.
Well, again, I dispute the idea that I did it, but yes, that's how that document was introduced here as a footnote to paragraph 26.
Okay, and that's the only public report that is cited in the complaint.
The complaint uses the plural, and so in 26 it says public reports plural, I believe, if you scroll back up, but you don't have to. And so that it cites one. For notice pleading, you wouldn't even have to drop that footnote. But no harm in doing it.
Anything.
But you didn't alert the court that there were other reports that had been issued by the states and the counties that had administered these elections refuting these claims.
On the elections test, it's just not true.
Really?
I mean, the courts, so there's this word debunked. These claims have all been debunked. And when the court doesn't read something because it lacks Article 3 standing, or because it lacks Article 3 jurisdiction, that means it does not reach the merits. Our threshold inquiry into standing in no way depends on the merits of the petitioner's contention that a particular conduct is illegal.
Okay.
And Anyway, so that's Whitmore versus Arkansas, 495 US, 149,
What is that?
55, 1990.
Why do you
There's, I
want
mean,
us to
that's
talk
just,
about that?
if a court doesn't have Article 3 jurisdiction, it's not a lot, it doesn't give an advisory opinion. You lose and you would have lost anyway if you had standing on this other claim.
We
It
just
means
filed
on
it
that
for
other claim,
kicks.
but they didn't have
Okay,
standing,
I
it
needed
never
a new
reached it.
PlayStation for
And
my
so
kid.
this suggestion that, oh, there was
needed
lots
some
of
billable
litigation and they all
hours,
lost,
and
that
that's
doesn't
what I
just
did.
resolve this
So
issue
sue me.
of the elections and electors clause. It's silent on it. And that silence is imposed by Article 3, which governs federal courts. It is not imposed on the Article 1 and Article 2 branches, which are not bound
Hey,
by
lady, stop yelling at me.
When they act, not the plaintiffs, but when they act in their Article 1 and Article 2 capacities.
You're aware that the federal district court in Arizona did address the allegations of fraud that were made by the Arizona plaintiffs with your clients?
I don't think so, because my recollection is, I don't know if I looked at it or not, because I really tried to stay away from the Arizona thing, because at least initially I thought Second Chance Club, they're irrelevant. That was my initial take. But my recollection, when they, again, if I looked at it and saw that, maybe I just don't recall, but my recollection is that everyone was running away from fraud because of Rule 9B. And it was, oh no, we're not alleging fraud, we're doing something else. And then they got pilloried in the press for that.
Not fraud.
That has to do with
Fraud, but not fraud.
what I'm calling actual fraud, as opposed to, fraud.
And when you say they were running away from it, the plaintiffs in the Arizona federal case certainly weren't running away from it.
Good for them. I'm glad they tried, but what I'm saying is I, as a consumer of media, watching these cases from the couch, wasn't aware of that. My recollection is, and maybe it's more Giuliani than Powell, but my recollection is that they weren't really getting into proving fraud with the particularity that is. I don't know, maybe that was the basis for the denying that maybe there was just no proof of it. And that was because they couldn't prove it. I don't know why. I don't recall. I wasn't aware, I don't think, of what you're saying right now.
I was busy. I went to.
Let me just read you an excerpt, and Emily, if you want to pull it up, Disciplinary Council Exhibit number 263 at page 24.
I don't know how to read. Hey lady, I just forgot how to read. What am I reading? What? I didn't write that. What, there's nothing on oh, wait a minute.
And this is the federal court decision dismissing the Boyer versus Ducey case. And you can see beginning with advancing, the paragraph beginning advancing, the court does address some of the allegations of fraud and the evidence that was provided to the court.
Okay, wait.
And
wait, I'm going to read it just before he answers. Advancing several different theories, plaintiffs allege that Arizona's Secretary of State and Governor conspired with various domestic and international actors, the Serbians, to manipulate, Tina, are you here? To manipulate Arizona's 2020 general election results, allowing Joseph Biden to defeat Donald Trump, allowing him. How dare we? What? In their particularity and plausibility, plaintiffs append over 300 pages of attachments, which are only impressive for their volume. The various affidavits and expert reports are largely based on anonymous witnesses, hearsay, and irrelevant analysis of unrelated elections. Yes, that pretty much captures what the election fraud thing was. Because the complaint is grounded in these fraud allegations, the complaint shall be dismissed. Because we went on this precedent, when an entire complaint or an entire claim within a complaint is grounded in fraud and its allegations fail to satisfy the heightened pleadings requirements of Rule 9B, a district court may dismiss the complaint or claim. Well, there you go, my little pets. It's in writing.
the court goes on for another couple pages.
Just gonna make a point of clarification.
Yeah, I
that
didn't write this either.
The Arizona court never held an evidentiary hearing. This was based peculiarly on an argument based solely on the allegations in the pleadings. And it was treated, I think, procedurally incorrect as a motion for summary judgment when the parties hadn't briefed a motion.
No,
for
it says
summary judgment.
the various
So
affidavits
this
and
is a-
expert
an
reports are
order
largely
on
based on.
motion to
anonymous-
dismiss
Never mind.
based solely on the allegations of the pleadings.
It says
Particularity, which is exactly what
they
I'm
did
saying.
look at the
And what
evidence.
the court goes on and addresses a lot of the
It does
evidence
look
that
at
was
the- it
presented
did. It says it
by
right
the
there.
plaintiffs in the case, correct?
They analyzed it.
So you never bothered to familiarize yourself with the allegations of fraud that your clients in the Gohmert case had made and how the court had ruled on those or responded to those.
As to them, as to Arizona, I mean, the thing that bothered me most about Arizona, as I recall, was the Me Vota case, where they extended the registration deadline
That's what he's saying.
because of,
everybody. I'll just
COVID.
translate.
And federal court doesn't have the
He's
authority to
speaking
do
bigot
that.
right now.
And so
That's what it
they stopped it, but they let, my understanding is 52,000 people registered to vote that were late
That
for
were
the
what?
deadline. And there's a Supreme
Oh,
Court
really?
case that says, got to have deadlines. So I think that was all
Okay.
illegal. And
Disenfranchised voters.
I think Mr. Richer more or less agreed with me about the number. He said it was
Don't-
30,000 in Maricopa,
don't-
and since they're about
Don't even
60%,
put his name
that
in your
correlates to
mouth.
about 50,000 statewide. Mr. Bowers thought it was it wasn't enough to turn the margin, and I believe what he was referring to there, Arizona has two ways that if there are illegal votes, there's two ways to deal with it. One is you can strike the election, and the other is you look at the votes and say, well, okay, let's say there's
You look at the votes.
they do a proportional reduction, basically. So if there's a certain type of vote that was illegal,
What?
and you know that like, let's say it's absentee ballots, and you know that one candidate got 60% of the absentee ballots
What?
and another candidate got 40%.
What?
And let's just for ease make it there were 100 illegal votes. You wouldn't take. You basically, that would be a 20 vote margin, the 60 to the 40. So you do a proportional reduction. When a
What?
proportional reduction, given about a 10,000
Who does
vote
that?
difference, taking away 50,000 votes wouldn't have been enough
Does
on a
anyone
proportional
do that?
reduction to make a difference, but it would have been enough to say
What?
this vote's illegal. I mean, again, there's two ways that an Arizona court could treat that, and a federal court could do what it
Right.
wanted.
But your clients didn't challenge that.
Right.
I forget why I went off on this digression. I apologize.
Well, here we go. Well, if you don't
Well,
know, we
sorry.
don't know.
But I'll remind you,
I
Mr.
think you
Richter
were-
says the plurality of
doing
the people
yourself
who
any
signed up
favors.
during that little window were Republicans.
I believe that's false.
Well, I'll guess you guys can agree to disagree.
Why do you believe that?
A newspaper article, actually, it's from a television station's website, but I think they're the plurality, meaning that the biggest number were independents. And I believe maybe the Republicans were more than Democrats, but so if you add Democrats and independents, there were way more. And if
Okay.
you look at any one group, I think there were more independents.
What? What?
But more Republicans than Democrats.
That's my recollection.
Objections, she's arguing with the witness, and I'm going to object to continuation of this.
What? This guy needs a safety net, and I'm about to throw him my little holy donut.
But going back, if I could, to
Wait,
the,
we don't have a question.
No,
pending
there's no
yet.
question. Shut up.
Wait.
No.
Just
Let me
shut up.
ask you about the allegations
loud.
of fraud in the Gohmert complaint. Those allegations of fraud or the contention that there was fraud was the basis for the Arizona Republicans becoming the completing slate of electors, excuse me.
Oh, uh-oh. The
I don't know
scheme.
that matters.
Oh, fuck.
In other words, you could have candidates from the moon or Atlantis.
Oh my
I don't know
God.
the archivists ability
what
to
it
screen.
was. They were
The
filing
question isn't
cases
so
so they
much
could justify the
that
fake
they
electors.
had the temerity to, let's just say that it's a blatantly false statement, rather than a premature act taken in the hope that the facts will fall into place.
Does that make sense? I'm stopping it for a second. I know this is probably everybody already knows this. I mean, I kind of knew it, but I kind of like, this is when I hear these things, it helps me really clarify what the scheme entails. And it seems fairly clear to me that the scheme for fake electors was to make sure that there was some kind of active legal entanglement at the time that the electors were supposed to meet because of 1960, because somehow they thought that would equate to the situation in 1960, which, as we just discussed, would not. This is very interesting to me. I don't know. I guess I'm just a nerd when it comes to this stuff. I apologize if it's really boring. I'll try and I'm trying to make it as funny as possible with varying degrees of success. Okay, good. Kathy, that's what you understand. All right. That's what I think I'm understanding here, is that that's the scheme. Shite.
The fact that they did that,
I don't want them to make it.
and
They're
the
going to make it
archivist, I
private in about
believe,
6
did
minutes.
forward
God damn
them
it.
to
Fuck.
to
We might
Congress.
we might get cut off.
The point of Gohmert is that has happened. Who, why, how? Gohmert case didn't care. The point was, it's gone to Congress, and there's these two sets, and they have to decide whether which to pick or exclude, and whether something is blatantly ridiculous, Atlantis and the moon, and you might put the Arizona Republican slate's paperwork closer to the moon than to a legitimate activity. I don't care which it is. The point is, they have to resolve that dispute. The process that they have for resolving that dispute is unconstitutional. That's what we were trying to do.
Okay, I think my question though, and let me have Emily, if you could pull up 276 again, the Gohmert complaint, and go to page 9. And my question to you, Mr. Joseph, was the basis for these Arizona electors or competing electors
private.
Was that both in, well, not both, but in Arizona, I think Georgia, Michigan, Pennsylvania, and Wisconsin, they took this step as a result of the extraordinary events and substantial evidence of election fraud and other illegal conduct. So would you agree with me that you were representing to the court, or the complaint in Gohmert was representing to the court, that the reason for this competing slate of electors was there had been election fraud in these swing states?
Just a minute, you started out by saying he had represented and then you shifted to the
complaint, because he says that he's not responsible for anything in the complaint because he didn't sign it, even though his name is on it. So I'm trying to, not have him preface every answer with that. So
is the question, did he represent, or does the question the complaint represent? Which one?
The complaint.
Shut up.
Could we have the paragraph blown up, please?
Shut the fuck up.
Question?
No.
Because the complaint speaks for itself. It says what it says.
Excuse me, sorry, I didn't quite get that.
If she's asking him to confirm that the complaint says something, that's an improper question because the document speaks for itself. It says what it says.
Yeah, I agree.
Okay. The complaint, and I'll refer you to page 2 of the complaint. And I'm looking at paragraph 4. This is not an abstract or hypothetical question, but a live case or controversy under Article 3 that is ripe for a declaratory judgment arising from the events of December 4th, 2020, where the state of Arizona and several others have appointed 2 competing slates of electors. Did you believe that was a true statement, Mr. Joseph?
It's poorly worded. I mean, what it should say is that there are competing slates of electors from the state of Arizona and several states. So did Arizona appoint? I don't think so. Did other states? I doubt it.
Oh my God.
But again, I didn't say this, and we didn't later advocate upon it. The point was, they're there. And what are we going to do about it? Oh my God, we don't have a process to deal with that. That's constitutional.
Oh my God. They just say everything they're doing. Please, everybody, stop thinking that there's anything clever about these folks.
Okay, let
There
me have you go to
just
page,
isn't.
paragraph 20, which is on page 7, Emily.
They're just hoping you don't notice what we don't notice. God bless America.
And I'm reading from
My
paragraph
God.
20,
Jesus
Mr.
Christ
Joseph.
on a cracker.
On December 14, 2020, pursuant to the requirements of applicable state law and the Electoral Count Act, the
Yeah.
Arizona electors, with the knowledge and permission of the Republican majority Arizona legislature,
Really?
convened at the Arizona state capitol and cast electoral votes for President Donald J. Trump and Vice President Michael R. Pence.
Well,
Do you think, is it your understanding that that's a true statement?
I don't think I would have known then. And because the PAL team had been representing these people, and I was brought on as a sort of auxiliary or
like a
additional
copy
and subordinate lawyer,
right.
I didn't feel it was my
Insignificant, one might say.
job to sort of second guess them on stuff
Okay.
that I assumed they knew. I wasn't being asked to sign it. If I had been asked to
Okay.
sign this, I would have
You're a
confirmed
yes
it,
man.
but I wasn't.
Okay, I got it. Oh,
And
I
what
wasn't
we
asked
heard
to
yesterday
review
was,
it.
no, this does not happen. Could it have
I wasn't
happened?
asked to review it,
I mean, it was,
girls.
I
I wasn't
mean,
asked.
theoretically,
Yeah, what?
all
though?
these statements I think could be true, except that the biggest one that's a problem is the permission.
Oh, okay.
Well, this wasn't being
Any
presented to the
problem?
court as a theoretical possibility. Would you agree?
No, it's a declarative statement, and it says what it says, as
Oh, it
as
says
the
what it
prior
says.
objection
So I'm
said.
gonna say that
But
other guy
again,
said it. I'm
won't
gonna say it too.
bore you with my,
Says
I
what it
didn't
says.
say this. I wouldn't have.
I didn't say it. I
I would have
wouldn't say
confirmed
it.
it, and I
Never
don't,
would've
and if
said
I
it.
would have looked,
He's
I would have
saying
found
it's
out that I think
everybody's
this is
fault
not
but
true.
his, Kathy.
But I didn't feel it was my job to confirm this.
I don't
and I didn't.
know. It's not my job.
But you are familiar with Article 2, Section 1.
Of what?
In fact, that's also quoted in the complaint,
Wait,
correct?
what? Of what? Of my
Oh, the Constitution,
car
I'm
repair
sorry.
manual? Oh.
That's the provision that says each state shall appoint in such manner as the legislature thereof may direct a number of electors equal to the whole number of senators, representatives, et cetera.
That's the electors clause, yes.
Right. And so you are familiar, or the electors clause gives that authority to the state legislature, correct?
That's gotten a little loosey-goosey in the last,
Oh, right.
I don't know.
What do
And
you think?
there's the Arizona independent whatever committee case,
Mm-hmm.
which lets the people by the referendum process create an independent commission. No, I'm sorry, that's the elections laws. I apologize.
Yeah.
So we're talking about the electors clause here.
Right.
And I'm sorry, I was talking about the elections clause, and you should, if you could repeat the question, because
All right,
they are
no
different in
jokes
some
with
respects.
Sure.
any
The electors
ethnicities,
clause,
Jim,
which you
please
cite,
stop. I
refer
love
to
you
many
so
times in
much,
you,
but
the Gohmert
watch the
complaint
dad
refers to.
jokes with things that are talking
States
about
that
other people. Like
the manner
I'm sorry, you know how I am.
each state shall appoint in
You know
such
how I
manner
am.
as the legislature thereof may direct a number of electors. So you understood under the electors clause, which you were arguing in this case, that it's the state legislature that determines the manner in which the electors for president are chosen.
Correct.
And you did familiarize yourself, or you, before agreeing to have your name put on this complaint, with the provisions of the state legislature in Arizona.
I think I took it as a given that in this day and age, because I think this is clear from the Bush v. Gore decision, that again, I haven't evaluated every state's law, but I know from these generic court
Apparently,
decisions
you haven't
that,
evaluated
well, it
anybody's
used to
law,
be a long time
Oh,
that
right?
sorry.
every state that there was no popular election of the president.
What?
Now it's entirely, I mean, there is no state where the legislature still appoints the directors without an election. So they have created an election process. I don't know this state by state, but I just know that it's been said
just
that every
know.
state
I
has
just heard
popular
it. I
election
heard
to
it on
whatever their
War
election
Room.
laws are of electors.
Steve
and
Bannon
that's
told
how,
me.
That's how that's done now.
Mike
So,
Lindell told me.
so I'm not sure what the question is.
Yeah,
Okay, so
I'm
the
not sure
Gohmert
either.
case was based on alleged violations of the electors clause,
Right.
correct? Okay, and my question to you is, you did something to familiarize yourself with how the Arizona plaintiffs, how in Arizona they appointed electors.
Right?
I think all I needed to do was determine that there was a violation, because once you're there, then the members of Congress or the vice president, whoever the decision maker is under the 12th Amendment, because it's not clear. Once they have a violation, then they have a dispute resolution process, and oh my God, that's unconstitutional. So what I was focusing on personally with regard to Arizona was the Mi Familia voter case. I don't recall what
which was getting people registered to vote.
the 52,000, allegedly 52,000 people that were allowed to vote late.
I'm sorry, but I read the Gohmert complaint, I don't know how many times, and I didn't see a single reference to that case. If you could enlighten me.
That is the electors clause violation of which I was aware when we did the Texas versus Pennsylvania, and to this day. I don't think we had to.
Shut up.
Again, you don't have
Shut
to plead constructive fraud with particularity.
Shut
The point
your
isn't really
fucking
why,
hole,
quite
you
frankly,
fucking bigot.
it's scary to me, but I don't think members of Congress
You know
need
what's
to have
gonna
a
be
reason.
scary?
If they just announce,
Prison.
I'm gonna dispute the vote, then
Prison.
you have an ECA, Electoral Count Act problem. But,
Prison.
so the
is gonna
government
scare
complaint had some gratuitous language about
Federal
fraud or massive
prison
fraud, but it didn't say
will
actual
scare
fraud,
him.
which is what how you're interpreting it. And
He
it didn't
didn't.
plead whatever fraud was pleading with particularity, so
didn't,
it's
Oren.
reasonable to assume that they meant constructive fraud, or that they didn't feel they had to specify, because they didn't, it wasn't really even material why the members of Congress were going to challenge the votes. Maybe they just didn't like the outcome, maybe it was just, bad sportsmanship.
What do you
but
think?
For whatever
Since you
reason,
were
they said they were
one
going
of their
to contest
lawyers.
it. And the process they had for doing so was unconstitutional. That's the point of the case.
Excuse me?
I think I've reached a stopping point. I don't know if it's good or bad,
No,
but
I think it's probably
I
bad.
think that seemed like an appropriate starting point.
Mr. Chair, can I just ask one question? Sorry.
Please don't cut us
Mr.
off.
Joseph, I say this, I'm sorry, yeah, okay. I say this at my peril in a room full of lawyers, but I'm wondering if you could
He's a public
explain
member of the
something
panel.
for me in a way a non-lawyer could grasp it. And that is how you can put your name on a pleading or a complaint. And with your knowledge and your consent, I assume, I think you've said that, and come later, in this case, 4 years later, and say, well, and I wrote down the word that you referred to, at least part of it as rubbish, and I wouldn't have signed it, and essentially pull yourself away from it. Wouldn't, by the same token, had the complaint succeeded, couldn't you come back and say, well, I loved it and it was brilliant? And aren't we dealing with complete after the fact kind of a thing? Either your
Feelings?
name on it means something, and this is what I'm struggling with, because as I say, I'm a non-attorney, or it doesn't, and you can have it either way.
Well, where that really comes into play, I mean, so there's a rule 3.1, which is deceit, and there's a rule 3.3, which is candor to the court. Candor to the court has a duty to correct after the fact, but it only applies to material things. The deceit rule applies to things maybe that aren't even material. And so timing is important here. And to your question, I mean, so these allegedly false statements, the eye-rolling or deceitful, whichever you choose, exhibit wasn't material because they could have done what they did even if that thing didn't exist. So it doesn't get into that rule 3.3 thing. And that's when that's after I joined the case. And I wasn't allowed to do anything until I joined the case, because before that I wasn't even admitted to filing.
Okay.
And after that, I wasn't permitted to do anything without the approval of the lead counsel. So I couldn't have, and it just simply didn't occur to us.
Did you
I mean,
ask?
they're making
Did
a
you
big deal out
ask?
of this document,
Did you bring
which I think is an
anything
eye
up?
roll, but I don't think it goes to deceit because it just didn't matter. So
Really?
that's
But wait,
the
I thought
prospective side of
materiality
it.
was
The
the other
retrospective
one,
side, which
not the
I guess what your
deceit.
question really gets at is how can you put your, be close to it, but then dissociate yourself from it. And this has to do with Rule 11. So if federal courts have rules, and those rules are the law of the United States. And the Rule 11 basically says you're responsible if you sign something, if you put it there, or if you later, you didn't sign it, you didn't put it there, but you later advocate upon it. I didn't do any of those two things. The people that put it there, I don't know who that is, people who put it there maybe are responsible for it to the extent that it's deceitful. That's the Rule 3.1. It wasn't material, so they didn't have to go back and correct it.
Run.
And the person that signed it, that's Louis Sessions, he's already been exonerated by the Texas bar. This same case was brought against him, and he was let off. So it's a little like how can you conspire with someone who's not guilty? I mean, but all I can say is those are the criteria that Rule 11 puts to what your responsibility is. You put it there, you signed it, or you later pushed it. And I didn't do any of those things. And then the Rule 83B says that that's the extent of your liability.
Oh.
What's the case that you say adopted this 3-part test?
What 3-part test?
The one you just described.
That's the rule, Rule 11.
I would say that's in Rule 11.
Yeah, right. It was adopted over time too. The original rule
Back
was
in
only the
76,
signer.
even 9.
And then in 93, they amended it to add
Right,
responsible, like who's
1993, yeah.
responsible.
Right, exactly.
And
And
that
then in
has a
97,
criteria.
all had a
Which
party.
doesn't include me. And so that
Right,
included Lynn
gotcha.
Wood in the Michigan case, but it didn't include
I'm
Emily.
hardly here.
Lynn. I'm an Emily, not a Lynn.
I'm
In
not
this
even
instance,
here.
I didn't. Sorry.
This isn't real.
Okay, I'm an Emily, not a Lynn, is what I
I'm
said.
an
So
NPC,
Lynn Wood was
Your
an
Honor.
instigator
I'm
who
a-
was
I'm a
listed in the
non-playable
signature block but
character, if
didn't
you will.
sign. Emily
Put it like the
Newman
kids
was
would. Okay.
a worker bee like me,
Okay.
who was listed in the
I'm a
signature block
basic
but didn't
bitch. Okay.
put it there.
If you want to go with the cool vernacular.
And so are, quite frankly, Brandon
I'm the lol
and
cow of
and Julie.
this project,
The only
really.
wrinkle is that they didn't. Emily had her own,
You'd
did her
think
own
it'd be
appeal,
Rudy,
and
but
they didn't.
no.
They appealed with all the other people,
Me.
the signers and the non-signers, and they didn't raise the non-signer issue until their motion for rehearing on prompt.
Right.
I'm sorry. So this was your. I mean, well, we
Wait,
both
what
had
was the
questions.
question?
Are we? Did I answer your question?
Did I answer anything?
Yeah, well, maybe you can clarify one more thing for me. I saw the names on the complaint. I saw Sidney Powell, Mr. Sessions, and right below that, I saw your name and then
Yeah.
others.
Weirdo.
Now, for the non-attorney, Sidney Powell and Mr. Sessions were the only ones who signed it.
Which complaint are you talking about?
Oh boy.
Well, we were looking at one and the page of attorneys was.
I don't think Sidney Powell signed the Gomer case, the one that I was involved in.
Okay.
It was
Oh.
Kleinhendler, Sessions,
Okay.
and then Joseph.
Whatever, but your name was clearly below the two primary attorneys.
Right.
Does that mean you didn't sign?
Yes.
And that means that,
If I may, let me just interrupt. There's a rule. So a signature in the old days meant a wet signature.
Uh-huh.
And there's another federal rule, and again, these are federal law, that says your name in a signature block plus you being the e-filer is a signature. I
Okay.
was not the e-filer.
Oh.
so essentially you can walk
Oh.
away from all the allegations in the complaint later on if that suits you.
Right.
I'm putting it a little tendentiously,
Bluntly.
but you get
That's
my.
okay.
I mean, if you need an analogy, it's almost like, I mean, it's kind of a participation trophy in the sense of you're involved, you helped. And it's almost like those sort of
did you get
acknowledgements at the
paid for
beginning of
that
the book.
participation
Where it's at the end of the
trophy?
pleading, but it's like, I'd like to thank so-and-so and so-and-so for helping on this. There's some element of that.
Oh, okay.
And so
Did you get paid for that?
it's an acknowledgement that you did work.
Did you get paid for
But
that?
you're not.
Did you get paid for
Rule
that?
11 does not make you responsible.
Did you get paid for that?
And whether that's good or
Did you get
bad,
paid for
that is
that?
federal law.
Sir, did you get paid for that?
I mean, I can see that you don't maybe like
Did you get
that,
paid for
but that
that?
is the law.
Did you get
Says
paid
me.
for that?
They disagree, of course.
Did you get
Yes.
paid for that?
Mr. Joseph, I just have one real quick, folks, we're talking about the team. Are there, to your knowledge, were there lawyers that worked in the Gomer case whose names are not on the bill?
Well, I don't recall, for example, if Peter Haller was a lawyer or a statistician,
Oh, or
but he
married to
was
Julia Haller, for
involved
that
in the
matter.
discussions, and he's not on the legal. I don't recall. Yeah, I mean, I knew that.
Oh, fuck. Okay, well, we literally reached our naughty moment. They go private right after. You gotta we didn't speed up enough, but that's okay. Holy shit balls. I'm telling you, I mean, I hope it's clear why I'm being so very naughty, okay? I really do. Please don't tase me, please. I can't. Please don't. Oh, mein Gott. Wow. Wow, wow. Wowdy, wow, wow. Oh, thank you, Carrie. You guys all did a great job too. I know my brain is killing me. It's time for a drink or something. I don't drink, but I smoke weed. So it's time for me to smoke weed, for you guys to do whatever it is you need to do to soothe yourselves. Holy poop buckets. Well done. Well done on all of us. My God, this was a group effort. What a fun day. I love this shit. Thank you for my Kraken, to my mystery Kraken gifter. I came back here about 20 minutes. I know. Neil, we'll kind of, I mean, yeah. I guess I would roll back. I try to explain what he's saying once in a while, but to be honest with you, I don't really understand what the fuck he was saying. Nobody does. Yeah, puff puff pass, no booze. That's right. Clean and sober. Holy shit, that case. SB! I know. Well, we all missed the end because frankly, we ran out of time and luck. I know. I need a shower after it. Yes. Lying liars and the liars who lie for them. Oh, well. All right. Well, I will see you tomorrow morning because I bet you this is still going on. So let's be naughty again tomorrow morning, bright and early. I know. He's so fucked. He is fucked. You're fucked, son. You're fucked. You're fucked, son. You're fucked. You're right fucked. Hey, big love to everyone. Hey, good luck, Oren. Good luck with the doctors. I'm definitely sending healing vibes and hoping that you're good and that everything's good and you're comfortable and it goes like, that was nothing. Yeah. I know. These are yes, no questions. 6:30 a.m., probably a little before, just like I did today, maybe about 10 minutes before. So I'll set a reminder. So please come and hang out with me in the morning. It's going to be Friday. Thank God it's Friday, Friday, Friday. Oh, Lee can't play with us tomorrow. All right, we'll catch up with you at the lounge. So there's also the lounge on Saturday with some spaced out trivia. For those of you who may or may not have joined us, you are certainly welcome. That's at 6:30 p.m. on Saturdays. But tomorrow morning at 6:30 a.m., you don't have to arrive early. Not super. I'm saying 10 minutes. Okay, come on, calm down. But come tomorrow morning 6:30 Pacific time. Okay, so that's 9:30 Eastern. Everything inside, outside, upside down. 6:30 a.m. tomorrow Pacific. 6:30 p.m. on Saturday Pacific. Etc. 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 Do the math. Come on, use your critical thinking brain. You got this. I believe in you. I believe you can add or subtract. Yes. Fuck yeah. Oh, well, good, Lee. I know you had a big week this week. Hopefully you'll be able to decompress a little. We'll make it extra fun on Saturday night. But yeah, great. I'm glad to hear it. I hope everybody's able to join us for the lounge. It'll be good times. Good times. Excellent, Carrie. I'm so glad. I really am glad. I'm so glad you guys have come on in. I just think it's great. I love the community that we built. I know I say that all the time. I know it sounds very important, very fancy. I suppose the fancy with the meeting tomorrow with the global leadership team. I'm going to be having tea with the global leadership team. Yep. They're quite fancy, you know. Good luck. Break a leg there, Lee. Give them hell. Or don't, Have them eating out of the palm of your hand, which I know that you will. All right, my loves. Have a great Thursday night. Don't forget, Radicalized Pod is tonight at, I believe, 7 p.m. Pacific. So coming up in a few hours. So please catch the Radicalized Pod. The link is in my preferred subscriptions. If you go to my homepage on at Real Lolo right here on YouTube, you can see a list of subscriptions that I recommend to you from different topics, and Radicalized Pod is in there. It's true. So if you are not part of the Radicalized Pod family, I invite you to consider. All right. Thanks again. Have a great day. Thank you so much for hanging in there. Long day. Lots of weird, boring, kind of weird shit, but we did it. So good.